right. Good afternoon, everyone. It's Monday, July 7th, 2014, and the Home Rule School District Charter Commission for the Dallas Independent School District is in session. We have a quorum present, and this meeting has been duly called and notices posted in accordance with the Texas Open Meetings Act, Texas Government Code, Chapter 551. So our first order of business, I will take a roll call, and if you will just say present, I would appreciate that. And my name is Bob Weiss. The board appointed me as interim chair to organize and start this first meeting. Ms. Elizalde.
Present.
Mr. Melson.
Present.
Mr. Flores.
Present.
Mr. Vasey. Not present. Mr. Mendez. He told us he would be coming a little later from work. Mr. Blackburn.
Present.
Mr. Ranger.
Present.
Mr. Garza.
Present.
Ms. Gutierrez.
Present.
Ms. Isamusa.
Present.
Mr. Freeman.
Present.
Mr. Oliver.
Present.
Mr. Reeves.
Ms. Reese present.
Ms. Reese, my apologies.
Okay.
Little nerves. And Ms. Sandell is out of town on vacation. With the roll called and a quorum present, the next item of business is an oath of office. We are a government body, and I have been informed that we will be officially sworn in to do our duty. So Ms. Gully will administer the oath. If we all stand, please. I appreciate it.
And raise your right hand and repeat after me. I state your name.
I,
do solemnly swear or affirm.
do solemnly swear or affirm
That I will faithfully execute the duties.
that I will faithfully execute the duties
Of the Home Rule School District Charter Commission.
of the Home Rule School District Charter Commission
For the Dallas Independent School District.
for the Dallas Independent School District
Of the State of Texas.
Of the
of the
state of
State of
Texas.
And will to the best of my ability.
and will to the best of my ability
Preserve.
preserve,
Protect.
protect,
And defend the Constitution.
and defend the Constitution
And laws of the United States.
and laws of the United States
And of this state.
and of this state,
So help me God.
so help me God.
Thank you.
Thank you. Congratulations to everybody.
Do you want us to sign it?
Yes, I did
Turn it in,
sign
do you?
this and turn it, yes.
Does everyone have the form? All right. Okay. First, before we move forward, I want to thank everyone for agreeing to serve. This is an important work that we have signed up to do. You have been appointed, and now we are sworn in, and our journey has begun. And you can tell from the agenda we have a lot to do. So under 2B, we have had posted and presented the resolution that formally appointed us and created the commission. We need to accept it. It's not an item that we are going to approve as such. Good afternoon. We'll take a pause and swear you in just a minute. So what I want to note on page 2 of page 4, when the board posted this, there was Melissa Malson was then at that time on the 19th the appointee of Trustee Jones. Subsequent to that, an issue arose and she withdrew her candidacy. Today, at roughly 12:30, Mr. Kevin Malson was duly elected, but is not officially in this whereas, but was duly elected to the commission and has now taken the oath. So I want to put that on record why his name is not there and someone else's is. So I would entertain a motion just to accept what the board has given us.
So move with the changing.
As amended,
Second.
as noted. Okay, Mr. Flores, Mr. Garza, is there any discussion? All those in favor say aye.
Yes.
I'm sorry.
Would you state the motion and the amendment?
Yes, the motion is to accept the resolution authorizing the Home Rule District Charter Commission to consider framing a charter for the district. And on page 2 of 4, the whereas on June 19th, 2014, Melissa Malson was nominated by District 1 Trustee Elizabeth Jones. She withdrew her nomination. Today at noon, roughly, the school board appointed Mr. Mousen in a duly called school board election.
I do have a little bit of concern, and it may be because I have never seen the agenda before in terms of participating in the creation of it. I assume this agenda was put together because you had some contact with the administration or the board, etc., and someone created this agenda. As I understand it, we are an independent organization. Independent meaning, once we are sworn in, this commission actually has no further accountability to anyone other than the Texas state law, or at least that's the way it appears to me. So my question would be, I believe that we should participate in creating the agenda, particularly when you're adopting something as important as this. I have concerns about this so-called resolution. I also have concerns about H and also the election of officers. But in light of the fact that we did not create the agenda, is there any possibility we could move some of these items to the discussion agenda so that the commission, would have an opportunity to discuss what we're about to do?
So let me break that in two parts. Very good question. The resolution is just a matter of putting before the commission that which the board adopted. We're not acting or changing the commission, the board resolution. It's simply a way to create, if you will, a line of decisions leading to tonight. So the only reason it's on the agenda, Mr. Ranger, is to call to the attention of the commissioners how we got to this starting point. No more, no less. And so to answer the second part of your question about the agenda, as the interim chair, I drafted it, and when we are done with this item, was going to make some suggestions about the order of business. So trying to break my response into two parts. One, we're not going to alter what the board passed. This is simply a matter of information and our saying that we received it from them. The question about order agenda items and how it's created, be happy to answer if we get resolution to accepting what the board has already adopted.
My concern would be, first of all, the commission being independent should not subordinate itself to the Board of Trustees of Dallas ISD. I think once they appoint us, we should act completely independent of the board. I'm not here for politics, and I'm sure most of us are not here for politics. I consider that to be a political jurisdiction. This jurisdiction is for a specific, legally authorized purpose. We get our authority not from Dallas ISD trustees. We get our authority solely from the state statute authorizing this commission. So I'm really concerned that we do anything that gives a notion that we're subordinate to the board of Dallas ISD. We're simply appointed. The legislators ordered them to appoint us, and a petition was brought. So I don't think that we should do, there's some language in here that has some implications.
Okay.
And we did discuss it.
I appreciate any other comments on the motion that anyone would like to make. Have you recognized at this point, Ms. Eisen-Newsom?
Thank you, Mr. Chair. Mr. Ranger, can you point out to me those areas where you have specific concerns?
Well, I don't want to hold up the agenda, but I'm just generally concerned about the implication of it. The statute doesn't require it.
If I might respond, I'm not being argumentative. Sure. I think as we progress through the agenda to answer Ms. Eisen-Newsom's question, that I think when we get through with the overview of the home district charter review, what the law says, your points will be amply made about our independence and autonomy. Again, I ask that this be put on, and frankly I asked the school board just to give me a list, a recital, if you will, of how we got to this point. So that's all this was intended for. It wasn't to breach our authority or to undermine what we're empowered to do by state law. And you will see in the agenda that that will become clear when we review what the statute actually says. Ms. Eisen-Newsom.
Mr. Weiss, given that explanation, could we not just accept this as a point of information rather than as a point of adoption?
Sure. So I would ask whoever made the motion to possibly amend it.
Mr. Chairman, may I make just one point?
Yes, sir.
As an example.
Yeah.
This is probably the most important concern I have. As an example, whereas on June 19, 2014, Dallas ISD Board of Trustees voted to accept the recommended teachers elected by the District Advisory Committee and appointed, and it named the teachers. There's a lawsuit that calls into question, very serious question, the legality of the appointments. And so, for us to adopt this, it seems to me, could jeopardize certain concerns about the commission itself. Because if those appointees are not legally authorized, it certainly could poison this tree as it can poison other trees. And so I'm concerned about that particular section especially, because that matter is being litigated.
Yeah, so noted. And again, what's the concern of the school district and how we got here. This again, I'll say last time, let's move this along, because I think the points you're raising further about what enables us to do our work will be discussed shortly, is to see how we want to manage with the board, I think appropriately try to share with us. So the maker of the motion, you can withdraw it, we can just accept this as a point of information and move the meeting along, or we can attempt to vote on it and just say it's a piece of information for the public record.
Well, I mean, I'll accept it as a friendly amendment from Dr. Eisen-Newsom.
Okay.
Thank you, Mr. Flores.
Okay. Is there a second to that?
As
Well,
the
let me
second,
just, yeah, I wanted, yeah, I'm just calling on
as
a
the person
second.
who seconded the motion, I have no problem with taking Dr. Eisen-Newsom's point of information added to that.
Okay.
Thank you.
Is everyone clear? There was a motion on the floor. It's been amended to, rather than use the word accept, that this is just laid on the table as a point of information delivered by the Board of Trustees, and we move the meeting forward. Is there any further discussion? If not, all those in favor say aye.
Aye.
Is there anyone opposed? Hearing none, the motion carries unanimously. Thank you all for the conversation, which gets us to the rest of the agenda. And I'm going to just take a minute to, I think, Mr. Beasy, right? You missed the swearing in. Can we just...
Mr. Mendez.
And Mr. Mendez, welcome. If you two will stand, we're going to swear you in so you can participate in the meeting. Welcome.
Thank you.
Would you please raise your right hand and repeat after me? I state your name, please.
I
Do solemnly swear or affirm that I will faithfully execute the duties of the Home Rule School District Charter Commission for the Dallas Independent School District of the State of Texas, and will to the best of my ability preserve, protect, and defend the Constitution and laws of the United States and of this state. So help me God. Thank you. There's a oath. Would you please sign it and pass it down?
Congratulations.
Thank you.
And welcome to the commission. Are we passing those in? Thank you. We'll just pass this down the table.
That's all right.
And in the meeting notice, it was noted that the order of the agenda could be moved. And let me just say that in thinking about how to launch this, I had good advice from Mr. Dino Harris. If you'll, in the corner, raise your hand, and I want to publicly give an acknowledgement for teaching me about open meetings, how to post. You might all appreciate, those of you familiar with the DISD, they're closed the week of July 4th, so he made a special effort to come in and take me to summer school. And I just wanted to... So the items on the agenda were my ideas. Let's just have that on the record. And thinking about it, I think there's probably a clear order to speak, particularly to Mr. Ranger's point, without putting words in your mouth, sir, that if you look at it, and you look at item D and you look at item G, it would make sense to take those together because D, the actual charter law, is part of the is embedded in the Texas Education Code. So I'm going to suggest that that's one item, and we will be briefed on that, and you will certainly have the opportunity to have questions answered by our legal staff. And then the training which is required about open meetings and Public Information Act will be taken together. I would ask that for those two items that we just hold questions in case there's an issue of continuity. The election of officers is there because, as I understood it from the board's motion, I am interim chair, simply to start the meeting. And in order to have an election that is transparent and open, I had asked Mr. Dino Harris to conduct it. And I put it up front because if someone else is elected chair, they would take over the remaining of the meeting. And if that's agreeable to everyone, I'm looking around the room, if you'll just nod your head. I think your point's well taken. So we would group the training about open meetings, open records, the whole code issue, and then the next item would be just to elect the chair of the commission, and whoever becomes the chair, I would turn the gavel over to, and that individual would run the rest of the meeting.
May I ask you a question?
Yes, sir.
Can you remain chair?
If nominated and elected, but I did not want to run the election. You cannot vote for yourself under the parliamentary rules. Pardon me?
I said if you're running the election, you can't.
Yeah, I can't. So, yeah, I can't nominate myself if I'm chair. So, if someone would like to do that, that's up to you.
Nominate.
Well, wait. I'm going to let Mr. Harris. Would you step forward to run the election? Thank you.
Okay, then you know what? Some understand how the election part works. The way it works, the first nomination will be for the chair. And so what we will do is see who all would like to nominate someone for the chair. And then after that, if there are multiple folks, then we'll take votes for both. Okay? So I first believe I saw Mr. Garza's hand.
Thank you, Mr. Chair. I'd like to nominate Bob Weiss as our permanent chair of this commission.
Okay, Bob Weiss has been nominated. Any other nominations?
Was that done? I'm sorry.
Okay.
Can you second?
So,
I affirm that.
all right. So no other nominations? Bob Weiss, you're the chair.
I'm the chair.
The gavel remains with you.
I was ready to pass it. All I can say is thank you for your vote of confidence. I intend to run this as openly, transparently, make this as much a learning experience from people who are more versed in public meetings than I am. If I stumble, I just ask your grace and get me back up. We will, I think, have good meetings. There'll be substantive meetings, and we have a lot of work to do. And I appreciate your confidence in me. I'm going to ask Mr. Harris to conduct a vice chair and then secretary.
Question, Mr. Chairman.
Pardon me?
Question.
Yes, sir.
Who decided that we would have a chair, a vice chair, and a secretary?
It was just a proposal by me in case I was absent that someone would
Okay.
be designated.
Well, I would suggest, since we are 15, and each of us is equally appointed, that there be some discussion on the offices some of us may wish to have.
Okay.
As an example, I remember when the Charter Review Commission of City Government, there was a chair, a first vice chair, and I think it was a second vice chair, which made sense to me. Now, secretary, I'm not sure what we would need a secretary for, because I'm assuming the board office. Pardon?
Well, could you just as a matter of decorum and for me to follow the discussion, if you'll just direct all the sidebars to me and questions. So keep going.
No, it's just that the idea.
So it was simply me because that's what I'm used to in the private sector, but I'm open to finding another way.
Well, I would like to
through this.
suggest that, if it's in order.
Yes.
I would like to suggest that we have a first vice chair
Okay.
and a second vice chair.
Okay.
There's another reason. I think it would give other members of this commission some kind of responsibility in the event we need them.
Yeah.
So it just makes sense.
I'm not opposed to that. It was a starting point. So, again, now that I'm chair, I guess I can conduct the next meeting. So is there someone who would like to nominate someone to be the first vice chair? First of all, let me say, are we agreeable to that method instead of a vice chair and a secretary before we take a vote? No? Okay, then let's have a discussion before we have a motion. Ms. Shirley Eisen.
I'm not opposed to a first and second vice chair, but I do think that there is value in having a secretary. Someone needs to keep up with the records. Someone needs to sign off on certain things. And so I think it is very important that we have a secretary. So, Mr. Ranger, if I could amend your motion to have a first vice and second vice, but maintain the secretary.
Good, good, I agree.
Okay, so we have a motion on the floor to have a first vice chair, a second vice chair, and a secretary. Is there a second to that?
I second.
Okay, Ms. Reed seconds it. We'll now have time for discussion. Mr. Blackburn?
Question, is it necessary for us to elect those offices tonight?
No, I just put it on there in case it was the will of the commission to do that. It can be rolled over to the next meeting, absolutely.
I'm not sure
Mr.
who else
Garza?
may know each other, but.
I tend to agree with Lou.
Okay.
If we could hold off the rest of the election of officers to
Sure.
the second meeting, that way we have an opportunity to work together, and then after this meeting, people will say, you know, I love serving, but that extra responsibility, I'm just going to kick it to my neighbor, you know, and just leave it at that.
Sure, okay. Ms. Heisen is.
I agree that there needs to be time for us to get to know each other. I know a few people around the table, but certainly not everyone. Rather than wait till the next meeting, could we move the election of those positions to the very end of this meeting, because that's what we're going to be basing it on anyhow. And then we come into the next meeting ready to roll up our sleeves and work.
That's fine.
Would that work? And then we don't have people.
I like that idea.
Okay, so we have a motion on the floor to have a vice chair, the first vice chair, second vice chair, and a secretary. And we are amending it, if Mr. Ranger accepts it and the second accepts it, to
Yes.
move that election to the end of the meeting before we adjourn.
Yes.
Is that agreeable?
Yes.
Is there any further discussion on the matter? Good. All those in favor say aye.
Aye.
All those opposed?
Aye.
Hearing none in opposition. Okay, Mr. Blackburn? So noted for the record. So, thank you for your confidence in me. And what I was going to do, since I do not know about open meetings and public information, was take that training module first, if that was agreeable with the body, so that we have a common understanding of how open meetings and open records work. Is that agreeable? If you shake your head as the next kind of module for you teachers?
Yes.
All right. So, as I thought about this, we're now in summer school, and I'm going to turn this over to our legal staff, and I think, who was going to go first? Okay. Ms. McGowan, would you introduce yourself?
Sure. Thank you, Mr. Chairman. My name is Letitia McGowan. I'm one of the in-house attorneys for Dallas ISD, and I'm also the district's public information officer for public information purposes. So if you've ever made a request, you made it to me. Hi. I am going to do the training on the Texas Open Meetings Act and the Texas Public Information Act. It is going to be an overview in the interest of time. You have a packet in front of you that has some basic information, and on the cover page there's also a link to the Attorney General's website, and there are 2 video modules on there. One is for the Open Meetings Act and one is for the Public Information Act. And so in your spare time with your favorite drink, you can watch those videos in addition to this information. Yes, that sweet tea. So, and I'm going to spend a little more time on the Open Meetings Act than I am the Public Information Act, simply because as a governing body, this is where it is really going to be applicable to you, whereas the Public Information Act is more administrative in function, but it is important that you know how it will impact each one of you. And just so everyone understands what the purpose is, because I know we have individuals who are coming from purely the private sector. Some of you have governmental experience. Understand that the purpose of the Open Meetings Act is to provide an opportunity for the public, including the media, to have access to the inner workings of the governmental body, to see how decisions are being made. And so that the public knows what's going on with their elected or appointed official. And as a general rule, any district business, any business of this commission, because as David and Lisa will talk about in a little bit, this commission is subject to both the Open Meetings Act and the Texas Public Information Act. And so as a general matter, any action that you all take must be in accordance with the Texas Open Meetings Act and the Texas Public Information Act. And this law applies to all governmental entities. And what you need to know is that if in a meeting has to comply with certain requirements. And so a meeting is considered a gathering of a quorum.
I don't mean to interrupt you.
Yes.
I do not have this document. I've been over here searching.
Okay. We will pass one down for you.
Thank you. I appreciate it.
No problem.
Thank you, Ms. Does everyone have the document that's been reviewed in front of them?
Yes.
Okay.
Okay, thank you.
Thank you. A meeting is a gathering of a quorum of the governmental body, and it is a discussion of the public business, and either the members are deliberating among themselves with the third party, and formal action is taken, or they're receiving information, and the public has an opportunity to ask, speak, or listen to matters related to public business. And so the other important definition is, what is a quorum? Because I said a meeting is a quorum of the body. A quorum is the majority of the governing body, unless you all otherwise define what a quorum is for you. However, even if a quorum is not present, the act still applies if there's a meeting of a subcommittee with authority to supervise the public business, or if members of the governmental body are trying to conspire to circumvent the act. And so when we're talking about this in terms of the Open Meetings Act, you may hear it referred to as a walk-in quorum. Walk-in quorums are illegal. And so you see there's a definition that's been provided, and it's when members of the group knowingly conspire to circumvent the Texas Open Meetings Act by meeting the numbers less than a quorum for the purpose of secret deliberations in violation of the act. If you'll recall at the beginning, I said the entire purpose of this act is to allow the public to know the operations and the deliberations of their elected officials. And so any attempt to circumvent that is going to be in violation. What is not going to be a violation, for example, it's not going to be considered a quorum in a meeting if you happen to be at a social function or at a conference or a convention and there happens to be a majority of you present. As long as you're not taking any formal action on behalf of this group, and any discussion about public business is only incidental to the event. So if you all happen to be, majority of you may attend the same church, or you may belong to an organization together. If there happens to be more than a majority of you, that's not automatically going to make it a meeting of this group.
Suppose Mr. Weiss is
I'm sorry, Mr. Ranger, if we could have questions at the end, please.
Oh, sure.
Thank you.
And may I just say, if you have a PDA-like device, this from my city plan commission is, would you just put it on silent in the audience or vibrate? Thank you.
And so there was some discussion earlier about the agendas. There are certain requirements as far as the agenda is concerned. There has to be appropriate notice that's given, and the notice has to contain the date, the hour, place, and the subjects that will be considered by the governing body. And because we are a political subdivision, we have to post at least 72 hours before the meeting. There is a provision for an emergency meeting. However, if you'll see what the definition of an emergency is, it's when there's an imminent threat to public safety or health, or there was a reasonably unforeseeable situation. If an emergency exists, the notice just has to be 2 hours before the meeting. We have to give special notice to the media, and we have to clearly identify what the emergency or urgent public matter or necessity was. And so it truly is an emergency. It's not I forgot to place something on the agenda and we'd like to talk about it. That doesn't constitute an emergency. There truly has to be an imminent threat.
I don't mean to interrupt, but the word emergency triggered my omission. There is food for the commission. and before we have a food desert and hungry rolling stomachs, I apologize. Again, I'm not used to having meetings where food is served, but however, I have just had it brought to my attention. So if any commission member feels like getting a sandwich or whatever's been prepared for us, it's in the back corner there, and just feel free to get up and get it. And my apologies for not letting you know that, but the word emergency just triggered. I apologize.
I understand. And so the meetings will be like now in open session. Under the Act, it does allow for a closed or executive session. However, they're for specific reasons. And, you know, I gave you an example here, the attorney-client consultation. And if you look at the agenda today, at item number 4, there's an example of language that's used. And so, for example, a governmental body can meet in a closed session to seek advice from the attorneys. The procedure for that, however, is going to be, it's going to be posted on your agenda. A quorum has to be present to begin the meeting. You'll first convene in an open meeting. Your chair will identify the open meeting, in the open meeting, the legal provision that authorizes you all to go into a closed or executive session. And you can deliberate about matters in the closed session as they relate to that posted exception. You can't go beyond that exception in that closed meeting. No formal action can be taken in a closed session. All final informal action has to be taken in an open meeting. And so after you've deliberated in closed session related to that exception, you will come back into your open meeting. And there has to be either a certified agenda or a tape recording of that closed session. And we generally keep a certified agenda. And as far as who can attend, only those individuals who are necessary for the closed session. The purpose of a closed session is so you all can speak freely and get, for example, legal advice as you need. It's not going to be open to the general public. And as I mentioned before, the final voter action has to be in that open session. There are criminal penalties if you violate or knowingly violate this act, or if you fail to maintain the proper record, or you participate in a walking quorum. And so that's the Open Meetings Act. Before I move on to the Public Information Act, I'll go ahead and answer questions about this. Mr. Ranger, did you?
I'll yield to other commissioners.
Okay.
Miss, who had their hand up first?
Go ahead.
Yeah, go ahead.
I just have a quick question on maintaining a tape recording of the meeting. Who will do that? Will y'all?
Board services.
Board services will do that. Okay, that's all. Thank you.
Mr. Garza?
You had mentioned that there were criminal penalties, you know, as related to this. When we're in a closed session, if a member releases this to the public, are there any penalties on that?
So it's about governing yourselves, honestly. You all cannot go out and take a certified agenda, if that's what's maintained, and give it out to someone. There would be penalties for that. But if someone comes out and they just happen to have a photographic memory and they decide that they want to talk to one of my friends over here to my left and recite every single thing that was said, there actually is not.
But if I go on the social media and recite what's occurred, there is or there's not?
Yeah, go ahead, Dave.
I want to comment on that just a moment. And by the way, I want to introduce myself first. I'm David Thompson. This is my partner, Lisa McBride. We're attorneys in private practice, and we've been hired as special counsel to advise the board. We're simply here to assist the commission if you need us from time to time. The provision Ms. McGowan referred to of knowingly disclosing the certified agenda tape, I think relates to a potential criminal offense or violation of the Open Meetings Act, particularly the closed session provision. What I always remind boards, and I believe it's applicable to the commission, the privilege in closed session does not belong to an individual. It belongs to the commission as a whole. It's not any one person's to decide to give away or not give away that. Again, it is the privilege belongs to the commission as a whole. There is an argument that if someone disclosed information that was privileged and discussed in closed session that actually injured the work of the commission, that person is acting outside of the scope of their official duties and might waive some of their immunities.
And also,
So
Could you follow up at another time, not today, but I have a question that I'd like you to explore regarding Jim Mattis's decision on this. I was based upon First Amendment, but not at this time. But if you could at another time explain it to me in light of that decision.
any other questions related to the Open Meetings Act? If not, I'll go ahead and move on to the Public Information Act, and again,
Ms. McGowan, I had, it's there when you, for notice of posting, is the 72 hours including weekend, that is, if it doesn't have to be during the work week,
correct.
it's just 72 consecutive hours.
But it has to be continuously available to the public even over that 72, over that weekend.
Right, so when we post for meetings generally, we post on the district's webpage, and it's also posted, there's a kiosk that's right outside that's always available to the public. And so the meeting notices are also posted there, and I'm sure it was the same for this meeting as well.
Would you recommend the certified agenda or the record? Oh, I'm sorry.
Yeah, please just address the questions to the chair so everyone gets a chance to ask. Mr. Blackburn.
Is there a particular place on the district's website where our meeting will be posted?
There is a tab for the Home Rule Charter Commission, and all documentation related to this body is there.
Ms. Isis.
Also, I was going to ask, did we want to consider having a website for the commission, since it is a separate entity? And I think it would get away from some of the confusion that has been discussed already about being subordinate to GISD.
I think I'll put it on the list of my...
So as we talk about our operating procedures, that may be one of the
there.
things that we want to consider.
But if the question is that subject to open, well, you're going to get into records, right? I guess websites. It's Mr. Ranger.
Yes. Do you recommend the certified agenda or the tape recording?
The agenda.
For closed sessions. Pardon?
We do the agendas.
Certified agenda? Now, what is the information that goes on that agenda?
It is generally what the exception was, in that no formal action was taken. But
Okay,
there can be some variation.
The reason I ask is this, we have the option to choose either of the two, right? The certified agenda I have seen, or known about, or heard about, had very little information. And of course, in the event a court ever subpoenas that document, there's no information there. So we can't choose to have a tape recording, right?
You may have either. It's not meant to be a detailed minute as you would think about generally.
Okay, I think we can do that. Any other questions? Give me. I would just say, not to beat this to death, under closed meetings, only members of the government have right to attend, but it says an employee may attend, would not defeat its legal basis. Could you explain that?
So, for example, yeah, if you all needed some additional information related to, I'll use a budget item, and the exception that you were using to go in closed session allowed that individual to be able to come in. For example, we've done it with real estate items is one of the things I can think of. We may have a staff member who has to come to the closed session to provide some information. That's not somebody who's an attorney, but they're going to be somebody who's necessary to provide information in that closed session so that that deliberation can occur.
Okay. Any other questions? This is complicated if you're not familiar with it, so if you don't have a question now, you get a chance to keep asking to resolve any doubt. Okay, Ms. Gallo?
I will go ahead.
Yes, Mr. Alman.
So, basically, everything needs to be very transparent.
Yes.
And everything needs to be out in public for everybody to understand.
Yes.
And nobody should have any hidden agendas. that they don't discuss in a quorum or as a commission?
Remember, all final action and votes have to happen in your open meeting.
Okay.
Good. Any other questions before we go to the next part of this?
I have a
Yes,
question
sir. Mr.
about
Finn.
the posting of the 72 hours before a meeting. In order to do that, is there like specific time frame for getting things on the agenda, or forgive me, but what's the process for
Yeah, it's a
getting
good
things
question.
on?
Well, and that is part of what you all should talk about is your operating process. You know, from this side of it, there is a calendar that is followed for items that are going to go on the agenda. They have to be turned in by so many days before the particular board briefing. And so that's something for you all to consider. How far in advance do you all want to require an item be placed, you know, sent around to be placed on the agenda? So that'll be an item for discussion for you all.
Yeah, I think the point's well taken that it's a mutually created agenda. I'm just learning about the timing of it to get it on so it's legally posted, then get it, you know, into the office here to get it on the website, to give it to 72 hours. And so we'll work through that when we're sorting out our rules.
And part of that too, as you all set your calendars, that will also help you determine what your deadlines are going to be to get items placed on the agenda as well. And let's see, y'all have that discussion later on the agenda. Moving on to the text. Yes.
Can I make one thing to be very sensitive about with the open meeting act, and think about it this way: to some extent, law is always chasing technology. When the Open Meetings Act was written, we didn't have the internet, we didn't have certain cell phones or text capacity or things of that nature. And when it talked about meetings, it was actually talking about real physical meetings where people are present. I think one of the evolving areas of law is, and you see it in other states in particular, is the issue of a virtual meeting, so to speak. And so I want to encourage you to be very careful about getting into email exchanges with a quorum of the commission. Because we all do it. We get an email at 12:30 at night and I had some brilliant thought and I hit reply all and I just want to share it with all of my fellow partners or whatever particular group. And before you know it, you have a back and forth taking place on the internet with a quorum, So that is an area, Letitia, that I would say to be very sensitive about is email exchanges that involve a quorum of the members of the commission.
The Texas Public Information Act is the mechanism that the public uses to get information and documents from a governmental body. And you have the general overview here. It is any information, any data, any records, it doesn't matter the format or the media that the information or the records exist in. It's all subject to the Texas Public Information Act. You may also hear it referred to as the Open Records Act. It's all the same thing. And we handle public information requests centrally in Dallas ISD simply because of our sheer size, so that we can make sure that we're responding to requests and they're actually handled through the legal department and they're actually handled through me. And just as an FYI for you all, in case someone asks, the information on how to make a public information request is actually on the district's webpage. There's a link at the bottom that says public information request, and it has all of my contact information there. We talked about how the law is still trying to catch up with technology. If you go to page 2 at the top, our emails concerning public business sent from your personal or private account concerning public information. Let me let you know that the answer is yes, 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 yes. And just in case you didn't get it, yes. Any record, whether it's email, a sheet of paper that I tear off from a notepad, a document that I pull out of a file cabinet. If you are discussing the public business, it is subject to the Public Information Act, which means anyone can request that information in that documentation. It doesn't matter what email account you're sending that information from. I know Board Services is in the process, and I think has now completed setting up for each one of you a Dallas ISD email account to use. I strongly urge you to only use that Dallas ISD account to conduct the business of this commission. We routinely get public information requests for emails. I promise you we will get multiple requests for all of your emails. I promise. I routinely get I get public information requests from reporters, from organizations, asking for people's emails. It could be for a day in particular. It could be for an entire year. You do not want to mix your private email account with your business email account. So please make sure you're only using the Dallas ISD email account to conduct the business of this commission. And it's important in a couple of respects. There is a duty to produce records that have been requested. And so if you're conducting business of this commission on your private email accounts, you're going to be responsible for pulling every one of those emails so that we can comply with the request. Versus if you are using only the Dallas ISD account, we can have our IT department pull those. And so make sure you're only using the Dallas ISD account to conduct business of this group. And you'll hear me say that a couple of times because I'm the one who has to deal with these requests. And I know there was some discussion, and I think for many years there was a question about whether or not, well, if somebody is sending it from their private account, is that still going to be district business? The legislature has done away with that argument. The courts have done away with that argument. They've all made it clear it is definitely, if you're discussing the public business, it is subject to the act. So I just want that to soak in for a minute. This is also true for text messages that or any other of those social media, you know, Facebook, Twitter, all of those things are very popular. Understand if you're talking about the business of this group, those are subject to the Public Information Act.
Ms. Eisen-Newsom.
I was going to ask you about text messages and phone calls, etc. Haven't had the previous experience with that. To that end, we're going to be provided an email address so we can. But what about cell phones for that purposes?
So, that's going to be part of the discussion. I think that you all will need to have about what your needs may be as far as the commission is concerned.
I'm fine. I'll bring it up at that time. Thank you.
Okay. And I'll just walk you through what happens when we receive a request. I'm not going to go into detail because you all are actually have to do this work. When the request comes in, we will send it to whatever department we believe has the information to provide it to us. And we have up to 10 business days to provide a response to the requester. That response may be that we're going to seek a ruling from the Attorney General's office to withhold that information. That response may be based on the amount of information that's being requested. We're going to need additional time. For example, if I have a request where what the result is 10,000 emails, that's not going to happen in 10 business days. And you all are looking at me like, 10,000 emails, I've had that request. So that's very real. You know, that's going to be very different than a request that asks for 2 emails, you know. So depending on what is being requested will determine how much time it takes. there are specific exceptions under this particular law. And I actually provided you all with a copy. If you go past page 3, you see 2 pages and it says TPIA exceptions. Those are just the exceptions that are in this act. There are also additional exceptions that are outside this act. For example, you know, if you've been to the doctor's office, you know you have to sign your HIPAA disclosure. That's an example. The ADA is another example. FERPA, which is the Family Educational Rights and Privacy Act, is another example, and it goes on and on. So these are some of the exceptions that exist to the disclosure of records. And so anytime we want to withhold information, we are legally required to request a ruling from the Attorney General's office, and that has to happen within 10 business days of receipt of that request. And so when you hear people saying 10 business days, the 10 business days is actually related to when we have to request a ruling. And so as requests come up and as people are more aware of you all and maybe requesting information that I may have to seek from you, when I get a request, there will be a timeline that I give you. Please respect the timeline and get that information back to me as soon as possible, because if there is an exception that exists, there's a very tight time frame for making sure we do what we have to legally do to protect that information from disclosure. I've given you a couple of examples of the type of information that get requested from us. And again, you see emails are on there, phone records are on there, but personnel files, those kind of things get requested. And so those are a general overview of these 2 laws. I've given you the links as well. You also have my contact information. Jack Elrod is the general counsel. He was not able to be here today. He's also available as well. And so I'll take some questions about the public.
May I ask a question? And I want to key off of the first point Mr. Ranger made this evening. If we are, and this is what I'm struggling with because of who we are and doing this for the first time in Texas. So if we are independent and we're using the DISD emails for the reasons you've ably outlined, and if I look shocked, I am. This is something to digest. But how does that work, given the independence that we have from the district? And I appreciate the support in council, which I welcome. Is there any potential confusion using a DISD email account? I would welcome it. I just want you to say something on the record about, is there a line there that we need to be sensitive to?
I mean, for us, there's not confusion.
Okay.
If you do, we know that you all are independent from the trustees. Right. There's not a situation, and you know, I can say in all my years of doing this, I've never had a situation where I've had a board member say, why are you complying with the Public Information Act, or why are you, you know, providing this information? And I don't anticipate that.
All right. Any other questions about what's being discussed? Yes.
I want to add one point of emphasis. I think many of us today, and again, because of our evolving world, we tend to think of and use email and text messages as substitutes for oral conversation. They're quick, they're informal, it's easy. They are not oral conversation. They are a written record. Think about what you write before you write it down and hit send. Because once you do, it is no longer an informal, off the cuff, spur of the moment substitute for a quick phone call. It is a written record that could be subject to the Texas Public Information Act, and I think
I promise you we will get a request for the email. I promise.
And I would say in my experience over several decades, and I'm sure Ms. McGowan and Ms. McBride will say the same, I can't tell you how many times I've heard someone say months after the fact when the request comes in, I wish I had thought about that for another minute before I hit send. So don't think of these as substitutes for oral conversation. They are not. You are creating a written record. Treat it with the seriousness that entails.
Any questions, Mr. Ford?
So just that it's clear for everybody. So if I take my office phone and I send Jerome a text message that has anything to do with that, then that's available and so you can ask for it.
Could be.
They ask, they say any, text messages, emails, Snapchats, whatever those things are. My instant chat, Snapgram, whatever those things. I tease my kids.
And that's exactly the kind
all
of
that,
request.
Every single thing that we would, if Dino sends us an email and we reply, every single one, somebody can ask for it, and we have to.
This is what the request will be. I want any and all emails from Edwin Flores to Shirley Isom Newsom from June 2014 through October 2014. Any and all. And it's intentional. We're not allowed to ask why someone wants information. We're not allowed to ask for the purpose, except to verify that someone has a legal right to have some information in certain instances. But that's exactly the kind of email or request that we would get. Yes.
Ms. Gutierrez?
Yeah. How far back can you go? I mean, this is the first time we meet. So how far back can somebody say, I want emails from so-and-so?
Yeah. So you weren't commission members before. So now, going forward.
So,
yeah, when you hit the
so let me just say there's probably a way to withdraw from being a volunteer. It's not on the agenda. I suggest you talk to the person who appointed you. Which is why this is on the agenda. As I told you, I'm from the private sector and this is brand new, and I appreciate all the good questions that everyone's asking, particularly from those of you experienced in the public sector. Could you just say one more time this thing? You have to get the Attorney General to approve every. What is the Attorney General's role?
So the Attorney General's office, by law, is the decider of what can be withheld from public disclosure. That's the way that the law is set up. And so there are certain things that by statute and by Attorney General formal decisions, they have said that we can redact, meaning withhold, without requesting an AG ruling. But those things are very limited. They include things like an employee's home email address if they've made an election to keep that private. But if, for example, someone asks for the attorney's memo to you all about some question that you had for some legal research, we are confident that that's going to be protected by the attorney-client privilege, but the way that this law is set up, we still have to seek an AG ruling to withhold that information. It is not automatic. So again, why it's very important, if we get a request for information and I have a deadline that I need documents by, that information is provided to me by that deadline.
Mr. Flores.
So I was going to ask a different. So for example, my doodles, somebody could ask for the doodles that I make during meetings, and they did notes and anything that I write down, they're entitled to have that.
And we've had some instances of that.
Did everyone understand that? I'm looking at my agenda. It's good. It's good. I'm just trying to remember names.
I mean, the reality is this, as you can see earlier, is kind of thinned out some, but they're still here. You all are, under the microscope now. And everything that you do, everything that this commission and this body does is going to be scrutinized. And the public has a great interest in knowing how you all are deliberating, what decisions are being made, and what documentation and information you all have used to make certain determinations. And so just expect to get requests for that information.
Ms. McGann, are we notified if any one of our emails are requested by someone else, that is as chair, if someone said, I want to see Bob Weiss's email, so the rest of the commission know that some, what is it called, an information
So
request?
generally what happens,
Am I notified?
if I have a request from you, I'm gonna have to contact you to probably get some information from you so you'll know. And so as far as what information is wanted by this body as it relates to requests related to this body, that's something that we can certainly have a discussion about. I know the board, they get a report weekly about certain reports, but that was per their request.
Okay, that's something to think about. I just didn't know that. Question, Mr. Freeman?
Yeah, just to clarify, can information be requested that doesn't have to do with the commission? Like if someone wanted to see my PDAS scores or something like that, would that be subject to?
Yeah, so, you know, we do have employees who are also on this body, and so there are other records out there related to you or, you know, former employees as well. Someone could decide they want to request a copy of your personnel file, they could do that. However, there are going to be documents in your personnel file, for example, your PDAS, that are going to be confidential under other laws that we would protect from disclosure.
Mr. Blackburn.
I'd like to return to open meetings just for one moment in terms of walking quorums, and I want to make sure I don't cross the line there. Can you kind of give a little bit of intent, especially where in reference to email? So if I email 3-4 people, not 8, where am I crossing the line there?
Right, so at that point, if you're only doing 3, there's not a quorum. The issue is going to come up if you email 3, then one of those 3 emails another 3, and then somebody emails a few more people so that the totality is a quorum, but it was intentionally broken up to not equal a quorum or to not visibly see that it was a quorum. That would be an example of, it looks like an attempt to purposely circumvent the act.
If I can comment on that, the lead Texas Supreme Court case on that point actually involved a school district in the 1970s that thought they had figured out how to avoid what was then a very new law by simply putting 3 board members in this room, 2 board members down the hall, and 2 members down the hall in this room, so that there was never a quorum in one place at the same time. And the staff or whoever was providing the information would simply circulate between the groups. And the Supreme Court spoke fairly strongly to that, as I think you can imagine, that defeats the purpose of doing the public business in public. And so, Ms. McGowan, I don't think this prohibits 1 or 2 members talking to each other. That's not what it's intended, but if the intent really is to, how can we wire around doing the public's business? I'll talk to 3, you talk to 3, you talk to 3, and we'll get everybody on board. That's the kind of discussion you need to be careful about. You know, if you read this again, it is knowingly acting in groups of less than a quorum for the purpose of avoiding a quorum.
Is that all communication, or is there any specific type of communication that we have?
It's any public business, and that relates to, since this commission has very broad authority, I would take it pretty broadly.
Mr. Ranger?
I suppose the Chairman Weiss is invited to speak at Alliance AFT, and there are 10 of us there. And he's talking about the commission's business or the issues we're discussing. Could that be construed as a meeting of the commission?
We've actually had some similar situations.
Thank you.
We've had similar situations, and so I can give you some examples of what has been done. You know, when this whole discussion started, there was going to be discussion at the city of Dallas about the charter, the home rule charter, and what was going on in the district. We actually posted for the meeting. You know, there's nothing wrong with being overly conservative, and if there's going to be any doubt, if you have advance notice that there are going to be, for example, 10 of you at a particular location, and that you know that on the agenda is gonna be items that relate to the public business that you all are responsible for posting the agenda, and it would simply say that you all are gonna be at the Alliance meeting at the time and the location and what your portion of the discussion is.
72 hours.
Right.
Thank you for the follow-up question. Okay, any other questions?
And as I said, we're available if there are some additional questions later. Thank you.
Okay, thank you very much. It was very informative, very thought-provoking. I just would say personally, it gives new appreciation to those of you who served on the public bodies of the city and the school district, the training you have to go through to conduct the public's business. So there's still food available. If we need nourishment, please help yourself. The next module was going to be an overview of the Home Rule School District Charter and combined with the orientation of the Texas Education Code and where is it situated. So again, if you'll hold your questions, I think the lead on that is going to be Mr. Thompson. And I know we probably have lots of questions, but if you'll give him a chance to do the overview, we'll take all the questions tonight. Thank you.
Thank you, Chairman Weiss. The Texas Education Code, and I'm going to kind of very hopefully expeditiously explain the structure of it. We're obviously not going to discuss every provision in it tonight. As the commission does your work, there may be particular sections you want to focus on from meeting to meeting, and obviously a lot more attention can and will be devoted to those at that time. The current Texas Education Code is contained in a book called the School Law Bulletin that is published by the Texas Education Agency following each regular session of the legislature. This book actually contains a number of other laws. It contains the complete Open Meetings Act, the complete Texas Public Information Act, a number of other laws, but it does contain the full Education Code and just the portion of this that applies to school districts. Not the higher education portion, but just the school district portion is 594 pages. So we're not going to cover that in loving detail tonight. There is a concept known as transactional memory. I don't know if any of you have ever heard this. You don't try to remember every single piece of information that you may need. You try to remember where you stored the information and where to access the information you need. So copies of this are available. If the commission, Mr. Chairman, wants your own individual copies, they can be purchased from the Texas Education Agency. It is also available in its entirety online, either at the Texas Education Agency website or at the state legislature, Texas legislature online. You can also access it. But if individuals want your own copies so that you could make notes, highlight, that is a resource that can be purchased from the Texas Education Agency if you decide you want that. Just very briefly, here's why this is important. Because what is the commission considering under Chapter 12? You are considering whether to move forward with a proposal to modify in some respects how some provisions of the Education Code might apply to Dallas ISD. So just very quickly, a little bit of background on the code. Up until the 1960s, Texas law was not organized into codes. It was all just sort of scattered in the general civil statutes. 20 years ago, the example I would have used, it would have been like walking into a library that didn't have an organizational structure, either by alphabetical or by subject. Just all the books were randomly in there, and you had to figure out where to find your book. Today, the example I use is it would be like all of your emails and no folders. if everything just was kind of scattered and not organized in emails, as many of us do. In the 60s, the Texas legislature decided to begin the process of organizing groups of laws around common subjects. There's a penal code, there's a tax code, there's a transportation code, there's an election code, there's a family code, and one of the first codes that was created was the education code. And what the drafters did was to go through all of these scattered laws that applied to school districts and try to combine in one organized place the laws generally applicable to school districts. Now, I do want you to know right up front, there were some laws that do apply to school districts that were never brought into the education code. But most of the laws of general applicability, that was sort of the purpose. Education code was one of the first codes created in 1969, significantly amended in 1971, and then over a period of decades, it just collected baggage, because every time the legislature met, stuff got added to it. Not much ever got repealed, but stuff just got added to it, sort of randomly, and it had gotten to the point where it was almost unworkable. In 1993, the legislature actually repealed the education code except for the finance provisions and required that it be restructured and readopted. And the code that we have today was adopted in 1995 by the Texas legislature. One of the commissioners who happened to be on the body that helped do that work and then was Commissioner of Education was Dr. Mike Moses, one of your former superintendents during that session at which it was reorganized. What we have for you today, and it's just the beginning point, but it will give you a sense of the flow of the code. And again, if the commission during the course of your work wants to spend more detailed time on particular provisions, obviously there's a lot more detail that can be provided. You will find a document that is the table of contents, and literally all this is an overview of how the code is put together. And just very briefly, the code is organized into chapters that are grouped around specific subjects. Each chapter is broken into subchapters, and then each subchapter is broken into specific sections. And so that's sort of the flow of it. Now, how is the code created? If you begin at the beginning, chapter 4, the general provisions, very few. Chapter 7, and really the structure of it is to flow. You think of a pyramid, we're either flowing up the pyramid or we're flowing down the pyramid, pick whichever works for you. But we start by describing the state level operation of the system. Chapter 7 is about the creation and organization of the Texas Education Agency and the State Board of Education. And one very important provision I would just point out to you as an example, section 7.003, right up front, specifically says that the Texas Education Agency has a limited grant of power, and that the broad reservation of powers is to the local units of government, school districts, et cetera, et cetera. The Commissioner of Education is created in Chapter 7. Does anyone know how does somebody become Commissioner of Education? Appointed by the governor. It used to be a position that was simply hired by the State Board of Education, just like a school district hires a superintendent. We've moved to a system where now the commissioner is actually a gubernatorial appointee and serves for a term that is coterminous with the governor's term. That's in Chapter 7. The duties of the commissioner are in Chapter 7. The structure of the State Board of Education. We have a 15-member State Board of Education. Just like you're a 15-member commission, there are 15 state board members responsible for the state of Texas, divided into regions. The election structure for the state board, the duties of the board are all contained in Chapter 7. Section 8, again, kind of moving to the local level or the regional education service centers. These are intermediate entities. There are 20 around the state. Dallas is in Region 10. Here in this area, they do not have regulatory authority. Their purpose is to facilitate and assist districts. Chapter 11 is where you start to get to very important provisions that relate to school districts, because Chapter 11 is the fundamental organization of school districts, the election of board members, the duties of boards, and many of the general powers, and that's what you're going to want to familiarize yourself with. I would call your attention to section 11.051 because it states, again, very upfront in chapter 11, a very important principle. And I want you to think about the school board and think about the commission in the same way. How much power does an individual board member have? Does anybody know? Edwin? Flores?
None.
Enter 0. And if anybody ever said, well, where does it say that? Section 11.051 says the board as a corporate body has the authority to do quite a bit to oversee the governance and management of the district, et cetera, et cetera. So there's quite a bit of authority invested in the board as an entity. There are many other provisions that boards have the power to adopt rules, regulations, policies, to hold property in the name of the district, et cetera, et cetera. Many of those provisions are in Chapter 11. Chapter 12 is the provision that deals with charters, and Ms. McBride is going to focus on that in more detail in just a moment. Chapter 12 was added in 1995. When we did that recodification of the code in 1995, the charter movement was emerging nationally, and it was incorporated into our code at that time. There are 3 primary types of charters that are described in Chapter 12. The most common is what are known as open enrollment charters. These are the ones created by the state that then function sort of parallel to or very similarly to school districts. A second type that we authorized in Texas are campus charters, where teachers and parents on a particular campus could actually create exceptions for their particular operation. And the third is the home rule charter, which was included in 1995. I will tell you, I was there for many of those discussions. I'm not sure that anybody had a strong sense of what that would be about, other than we want to give school districts some authorities to look at some of the things that charters are looking at, but probably not a real, it was probably not a decision at that time that there was a lot of information about from a state or national perspective. That is a provision that has never been used in the state of Texas until you were all sworn in a little bit earlier this afternoon as members of, as far as I know, the first commission ever created under this provision since 1995 in the history of the state of Texas. And we're going to look at that in a little more detail in a moment. So again, we're sort of transitioning. Chapter 13 is about how you change boundaries. It's the organization of school districts. You might be surprised to know that as recently as the end of World War II, there were over 5,000 school districts in the state of Texas. And I think we're down to 1,029, somewhere in that range today. So there's been a lot of consolidation over the years. But any provisions that relates to how that would be done are all in Chapter 13. Chapter 21, and I'm going to hit some of the big ones. So we've now talked about the state level, we've talked about organization at the local level. Chapter 21 and 22 deal with your employees, and particularly focusing on your professional employees. Chapter 21 deals with certification, contracts, and non-renewal provisions or due process rights, I will put it that way. And all of the details when it comes time, as it does occasionally in districts, to separate the due process requirements are all contained in Chapter 21. Chapter 22 also relates to your employees. It includes many of the benefits provisions, health care, duty-free lunch, the immunities that your employees enjoy as long as they're acting within the course and scope of their duties. All of those provisions are in Chapter 22. All right, so now we know what the state's supposed to be doing. We've talked a little bit about the district. We've got some employees. What do we need next? We need some kids. So Chapter 25, Chapter 25, all right, we got teachers, let's have school. Let's get some kids in here. Chapter 25, you get the students. Chapter 25 talks about who's eligible to attend public school in Texas, who's required to attend school in Texas under compulsory attendance, which district do you attend school in? How do individuals transfer from one district to another? All of those provisions related to students are in Chapter 25, and obviously a number of other provisions, but that's the primary focus there. Chapter 26 deals with parental rights, primarily, Lisa, I would say, dealing with access to information. I think that's what's really key. Would you agree, Letitia, particularly about their children? And I think that's a particular focus. Chapter 28, all right, we got teachers, we got some kids, now what do we do? Well, let's talk about what we're going to study. So Chapter 28 is the curriculum. And so everybody's heard about the TEKS or the TEKS or however you want to pronounce it, the essential knowledge and skills, which are one of the things that are within the power of the state board to adopt. All of the statutes relating to curriculum, to what are we going to study, are in Chapter 28. Chapter 29 are your special programs for kids who need particular kinds of extra services. And that may be special education, it may be bilingual or limited English proficiency assistance, it may be comp ed, it may be gifted and talented. But those services for students that need those special programs, those are all in Chapter 29. Chapter 30 are some programs that the state operates in particular to deal with primarily students who are blind or visually impaired and deaf or hearing impaired. Chapter 30A is a growing area in Texas. It's virtual schools. Most kids attend and most courses are taught in real settings by real teachers and actual interactions, but we're beginning to see a statistically measurable number of courses that are taught each year virtually, and I think that will probably increase over time. Chapter 31, all right, we got teachers, we got kids, we know what our curriculum is, we need some materials. What are we going to work with? Chapter 31 used to be about textbooks and was significantly revised a couple of sessions ago. It's broader now. It refers to instructional materials in a broader sense, and that includes not only kind of classic textbooks, but it also now includes technology-based instructional materials. Funding is provided by the state for that purpose. And districts have a responsibility to make their purchases. Chapter 32, again, dealing with technology, in particular computers and computer-related equipment. The primary observation I'm going to make there is, again, statute, my experience is statutes tend to chase technology because technology is evolving, and for our legal systems to kind of keep up with it, I think is something the legislature has to work on every session. Chapter 33 are your extracurricular programs, counselors, libraries, everything related to extracurricular activities. Who can participate? How do we regulate extracurricular and co-curricular activities? All of those provisions are in Chapter 33. Chapter 34, okay, we know who ought to go to school. How do we get them there? Transportation. So everything related to transportation is in Chapter 34, the laws related to that. Chapter 37, gosh, with all of these 5+ million kids that we now expect to come to school, some of them are going to misbehave. How do we provide for discipline? How do we make sure classrooms are safe? How do we make sure that teachers and other students are able to engage in learning? But how do we also address the needs of those kids? Anything the state kind of wants to say to us about discipline is in Chapter 37. All right, so now we've got teachers, we've got schools, we've got materials, we know how to get them there, we've got transportation. Chapter 39, we've probably had as much controversy and conversation about in the last couple of years as maybe anything else in public education. This is where you will find everything related to testing, assessment, and accountability. And those are two different things. Assessment is the state testing structure. Currently, we've migrated to STAR. We began this in the early 80s. I think the original test was tabs, and then teams, and then TOS, and tags.
The original test was both.
Yeah, we've come through. You've seen you've seen all of these, and we're currently in STAR. So the assessment system related to tests is in Chapter 39. And then what do we do with that information? How do we convert that information into ratings for campuses, for teachers? I'm sorry, not for teachers. Campuses, districts, assessment and accreditation is Chapter 39. Chapter 41 is a big break. We're now into funding. So we know how to operate schools. So when you get to Chapter 41, the big question becomes, how are we going to pay for it? Chapter 41 applies to those school districts that have enough local property wealth that they're required to disperse some of it, typically by sending it, the common phrase that is used is recapture. If you've heard that phrase, all of those provisions, all of the laws related to that are in Chapter 41. Dallas, like Houston, is always right on the bubble of recapture. Other districts in your area, Highland Park, Plano, certainly others, are actually into recapture. The two biggest urban districts in the state, Dallas and Houston, are educating a lot of needy kids, but the district itself looks wealthy on paper. So you're always right on that bubble. Chapter 42 is the funding structure for every other district. For those who are not subject to recapture, Chapter 42 has all of the basic formulas, all of the requirements for funding. I do not encourage you to run home and start reading that. It will make you cry. It is hard to make sense of. And just by full disclosure, our law firm, we are representing Dallas ISD and many other districts around the state, about 1.9 million children. We are representing in suing the state over the school funding system. So that's something that we'll keep working on. Chapter 43, we have in Texas, we actually did something very far-sighted back in the 1800s. we set aside public lands to support many educational institutions, not only some colleges, originally UT and A&M, but also to support our public elementary and secondary schools. And guess what happened in the 1920s, 30s, 40s, 50s? We struck oil on an awful lot of that public land. And so the corpus is not spent. We set it aside. The interest on that helps pay for education. I will be very candid. It is not a huge amount. It's probably $300 to $350 per child, but it is a help. And that was something that we did as a state many decades ago. Actually, going back to the 1800s. Chapter 44 are all of the provisions that school districts have to follow related to
Thank you.
Related to adopting budgets, making purchasing decisions, spending money. Public money is public trust, and so all of the provisions that districts have to abide by when they make purchasing decisions, things of that nature, are in Chapter 44. Chapter 45 is primarily about bonds. And most of the provisions there deal with the authority of districts to sell bonds, what bonds can be used for. Bonds can't be used for just normal operating costs or salaries, things of that nature, but they're longer term and for longer investments in communities. And Chapter 46 is the last one that I'm going to mention, and that deals with state support for facilities, which a few districts in the state get. Dallas does not receive direct assistance from the state for facilities because of your wealth level. But some districts do, but the number of districts that are covered has actually been declining over the years. So again, we start with the state structure, then we go to the district, you eventually work up through employment, curriculum, and the last several chapters end with how you pay for it. So I think in about 20 minutes, that was a quick overview of 594 pages of statute. Again, the actual language will be available to you, Mr. Chair, and particularly if there are particular areas that the Commission, in the course of your work, wants to spend some time on, then obviously we can focus on those particular. So that's the overall structure. I'm now going to turn it over to Lisa McBride, my partner, to focus particularly on Chapter 12. And you have the full text of the sections of Chapter 12 that apply to you, because again, part of what the Commission's authority and prerogative is to look at this vast kind of realm of law that governs the operation of school districts and ask the question, are there some things we would like to do differently and better? So that's the overview.
Yeah, so before we get right into 12, I want to just thank Mr. Blackburn, I think you had your hand.
I'll wait on questions, but I did want to see if after questions, before Ms. McBride speaks, if we can take a 5-minute recess.
Yeah, I was going to, I'm looking around. Mr. Garza.
Thank you. I have two questions, Mr. Thompson. Number one, if you could just briefly tell this commission, because I believe the DISD does have a campus charter. You could briefly just let them know, where it is, how it's different than the other campuses.
Yeah, I believe you do, and I'm going to defer to people here.
Gay P. Allen.
Yeah, I'm going to defer to
one at a time.
To boots on the ground, who are probably going to know more about that than I do.
So just to clarify your question for the rest of us, you're referring to one school as a charter school?
One campus charter within the DISD.
Okay.
As we went over number 12,
right.
DISD now fits two categories.
Correct.
Number one being a campus charter.
You already have, right.
Okay.
We did have two, if I could say. Harley was a campus charter first, and then P. Allen.
Right.
Could
but
you
I
just
think
say that?
currently yeah.
Could you just direct it to the rest of us? I didn't hear you.
Oh, I'm sorry. I was saying at one point the district had two campus charters. N.W. Harley was the first one. It is now closed. And then P. Allen is the second one and continues the charter.
To operate.
Yeah.
Ms. McGowan, did you want to
Yeah, no,
comment?
that's really what I was gonna say. And so with the campus charter, that it's still part of Dallas ISD. The charter was, yeah, it's an internal charter. They are still subject to district policies, but there are additional things that per the charter that's been granted that they do. I can't recall off the top of my head the details of it, but we do have one.
Basically, it's curriculum. It allows more curriculum at the teacher level and the campus. They can do things differently than what's done to the rest of the campus.
Thank you for the clarification.
So that's number one. And number two, Mr. Thompson, I had to do, and as you were dealing with chapter 42, you talked of funding.
Right.
My big question is, what is the funding for this commission, and from where is this coming from? You know, we've talked about many different things. I mean, I've heard earlier cell phones, the email address, all this type of situation that's going on. I'm a big guy, and I just like to say, okay, before I move forward and make decisions, how much money does this commission have to work with to do their task?
If you look on the resolution that you simply acknowledged as a document at the start of your meeting on page 3,
okay.
I'm going to be very candid with you. I think at the time this option was put in statute in 1995, a lot of details were not addressed, and one of those very obviously is any kind of support or funding. Mr. Ranger, you are 100% correct that the commission is independent and operates subject to the statute, and you're not subordinate to the Dallas ISD or the Dallas ISD board or the city or any other entity. You have your own responsibility, but you have a responsibility without a lot of resources. And so what the board did discuss, and what you will see reflected in the resolution on page 3, Mr. Chair, is close to the bottom, about the fourth whereas from the bottom. The board directed the superintendent to provide reasonable and appropriate resources to support the commission for the duration of its tenure. So, meeting facilities, staff support, other assistance that you need. I don't know, Ms. McGowan, that a specific budget has been created, but the superintendent was asked to provide reasonable support. And I want to emphasize on behalf of Lisa and I that we are not here at this meeting or any meeting to tell you what to do. We are here to provide you assistance if you need it and want it. We are simply a resource that is available to you as you wish to use it. But that is actually one of the important things that the board thought about and made that specific decision to not leave you. They asked you to serve, but they didn't leave you hanging. They did direct the superintendent to provide reasonable and appropriate support.
Let me just add that because when I was first contacted about being the interim chair, I met with Mr. Cowan, who's then president, and asked that question. I just said, you know, what kind of support is involved here from space, time, staff. And so I think the following Thursday, this language was inserted in there. But I think as we go along and we look for help, for financial help to obtain the resources that we need, I think those kind of clarifications need to be asked at the time. Again, I want to say there's been nothing but, for me to get this organized tonight, support from Mr. Harris and his staff to at least launch us. And that language is something I inquired about. Now, I do want to recognize Mr. Blackburn's recess question. It is roughly at 7:13. We'll take 10 minutes. We're now in recess. Thank you, everyone. Make sure we're gathered before I officially reconvene. I see everyone got there. Can we get the door closed before we officially start again? Thank you. Thank you, everyone. Remember, if you have a PDA, one of these electronic kind of things, please put it on silent or turn it off. The Home Rule District Charter Commission is now back in session at 7:25. The next order of business is a briefing on Chapter 12, and Ms. McBride is going to do that for us. But before she gets started, I'm just trying to do some clock management because several of you in the recess wondered how long this goes. So when you look at the agenda, we have this to go through. We're not going to get a quiz on how much we've mastered of it. Again, this is the intro course. Then we wanted to hold an election before we left. The other items have to do with the proposal of how we would operate. That can be rolled over as you look at it and make your own suggestions, edits, and corrections. And then it was, there's no closed meeting, it's just perfunctory to put it on the agenda. And then there was a quick item on communication protocol, and that was simply to say if you're going to speak to the media, you represent yourself, and that possibly the chair would be the official spokesperson. But I was going to suggest in that item that we can draft a little statement about how to do that. And so the two items I do want to get through in a reasonable fashion is the overview of Chapter 12, because that's why we're here and which gives us the authority. And then just be sure we hold that election for first vice chair, second vice chair, and secretary. And then if we don't have to schedule the next meeting, I will just ask you through your TISD email to let me know your schedules. I know one person has a work conflict. I'm going to be traveling, and so I will, with the help of my officers, try to consolidate that to get a reasonable next meeting date, and then ask you for agenda suggestions. So if that's agreeable with everyone as kind of a course of business, I'm going to turn this over to Ms. McBride.
Good evening, everyone. Again, my name is Lisa McBride, and I'm going to talk to you now that you've had an overview of the Education Code, specifically about Chapter 12 of the Education Code. That's the other document that you had in your blue folders. One document that you had on one side of your folder was the table of contents of the Education Code, and the other document, believe it or not, even though it's 13 pages front and back, is only the relevant sections of Chapter 12 that apply to this commission. Chapter 12 is actually much larger than that, and we decided not to copy all those pages, pages that don't apply. As David mentioned in his intro, Chapter 12 really deals with 3 classes of charter. A charter that would apply to a campus, a charter that would apply to a specific program, like a charter school, a 501c3 wanting to operate a charter school, and then what this commission has been formed to look at, which is a charter that would be impacting an entire school district. And so as David was mentioning about the Education Code, it's divided into chapters, Chapter 12, and then subchapters. And so the two subchapters that you have that are excerpted in your materials are subchapter A, which is just an overview of the charter provisions, and then subchapter B that specifically applies to the home rule charter school district. And so what you don't have is subchapter C, which would apply to a campus charter, and then subchapter D that would apply to an open enrollment charter school. So just wanted to give you that overview. And I'm going to walk you through the excerpts of Chapter 12 that are provided for you, because I think it's kind of helpful to see those provisions in context so that you have an idea kind of at least what the legislature's idea in terms of the organization and structure of what is going to be guiding this commission. So 1201, which is on the first page of the document that's provided to you, just gives you a general idea of what the legislature thought should be a key purpose, whether a school district was adopting a charter at a campus, whether a 501c3 was creating a charter with the state of Texas for an open enrollment charter school, or whether a commission was deciding whether to form a home rule charter school district. And that is to improve student learning, to increase the choice of learning opportunities within the public school system, create professional opportunities that will attract new teachers to the public school system, establish a new form of accountability for public schools, and encourage different and innovative learning methods. This chapter, meaning Chapter 12, is to be applied in a manner that ensures fiscal and academic accountability. I state that because that telegraphs for us some of the provisions that are still going to be responsible, that this commission cannot opt out of because the legislature feels that they are so important. So keep that in mind, fiscal and academic accountability of persons holding the charters issued under this chapter. 120011 kind of gives you an idea that a charter is an alternative method of operation. It's defined right there in 12001. And it's an alternative method of operation for an independent school district, which is what we're looking at, for a school campus, that would be the campus charter, or an educational program, the open enrollment charter school. 12002, just as I telegraphed just a moment ago when David, during his presentation to you, tells you about the three classes of charter. They're right there identified for you. One is a home rule school district charter that we're going to talk a little bit more about, campus or campus program charter, and then 3 is the open enrollment charter school. Now turning to subchapter B. So that was the highlights of subchapter A. Subchapter B is just going to be talking about the home rule school district charter. And just as a preliminary matter, when you're talking about a home rule school district charter, the education code says that the fact that a school district has a home rule school district charter does not affect the school district's boundaries, and it doesn't affect taxes and bonds that have previously been issued. In fact, the entity that is created is still a school district, but still has taxing authority, and you'll see that in subchapter B. I want to skip 12002 for a moment and 12013. They talk about laws that continue to be applicable to a home rule school district, so laws that the commission would not be able to opt out of, because I just think it's sequentially out of order. I kind of want to go through the provisions that talk about how we got to this point and how do we go forward in terms of what this commission is required to do. So if you will turn with me to 12014, which is actually on page 4 of 13. This begins the provisions that really talk about why this commission was formed. This commission, what triggers the formation of this commission was one of two things. Either an action by the board, 2/3 of the board adopting a resolution to look at going to a home rule charter, or receiving a petition signed by an appropriate number of residents. And what happened in this particular case is the board received, obviously, a petition that was signed by at least 5% of the registered voters of the district. And upon receiving and verifying that, then 12015 says that not later than the 30th date of receipt of that petition, the Board of Trustees had to form a 15-member charter commission. Those 15 members had to be residents of the district, and then in 12015B, it talks about the specific composition of this commission. A majority of the members of the commission, or of the members appointed to the commission, have to be parents of school-age children, and at least 25% of the commission have to be classroom teachers selected by the professional representatives of the DAC. The Charter Commission has a year to develop a proposed charter for the school district. After that year, the commission of the commission, the authority of the commission is void. So that's sort of like the outside time limit on the authority of your work that you have ahead of you. D is very important because it's why we spent so much time talking about both the Open Meetings Act and the Public Information Act. D of 12015 says the Charter Commission appointed under this section, under this subchapter, is considered a governmental body. That's why you took the oath of office as governmental officers for purposes of, and you'll remember these chapters, 551 and 552 of the Government Code. That's the Open Meetings Act and the Public Information Act. So right here in the provision that sets up this commission, it says the Public Information Act and Open Meetings Act applies to you as you go forward with your work. I just thought that that was important to point out to you. That's why we spent so much time tonight kind of going through the provisions of those two very important laws. 12016 talks about the necessary content of any charter that's developed by this commission. This is the minimum. Of course, a charter can have more than this, but a charter must describe the educational program to be offered by the school district, provide that the continuation of the Home Rule Charter School District is contingent on, and we kind of telegraphed this from the beginning, acceptable student performance on assessment instruments adopted under subchapter B of Chapter 39. Remember when David was talking about the Education Code, we talked about Chapter 39 being the academic accountability section of the Education Code. Compliance with other applicable provisions of Chapter 39 regarding accountability, which would include both financial and academic accountability. Specify any basis in addition to those contained in the subchapter on which a charter may be placed on probation or revoked. And we're going to talk about, towards the end of my presentation, the provisions that are contained right in Chapter 12 for a charter to be placed on probation or revoked. But any additional reasons that this commission would have to put in the charter. Describe the governing structure of the school district and or the campuses, and specify any procedure or requirement in addition to those contained in Chapter 38 that the district will follow to ensure the health and safety of students and employees. Remember, Chapter 38 was that provision that David talked about of the Education Code that dealt with school safety. Describe the processes by which the district will adopt an annual budget, because remember, the school district still will adopt a budget and will still be responsible for taxation, including a description of the use of program weight funds. So we're going back to Chapters 41 and 42 that David was talking about in terms of school finance. And describe the manner in which an annual audit of financial and programmatic operations. Remember, at the very beginning, the legislature telegraphed to us that what was still going to be important, even going through this Charter Commission process, is accountability, both academic and financial. So providing right there in the charter the method by which an annual audit will be done of both the financial and programmatic operations of the district. And then 8 is a catch-all, include any other provisions that the Charter Commission deems appropriate. So that is the content of this charter that the commission could develop. We know that it can take up to a year for the commission to come up with this charter commission, and if it does not, sort of the appointment on this commission becomes void. Once a charter is developed, what happens? Where does it go? I think a lot of us know that this is an elective process, so ultimately it goes back out to the voters. But there are a couple more steps before it goes to the voters. First of all, it goes 2 places. It goes to the Secretary of State's office, so that the Secretary of State can determine is there any impact on the electoral process, such that it would need to be submitted to the Department of Justice. If the Secretary of State's office determines that it does need to be submitted to the Department of Justice, actually it's the Board of Trustees that have to submit it to the Department of Justice, and the Department of Justice has an opportunity to review that. Typically, under normal circumstances, the Department of Justice takes about 60 days to review something to determine whether or not it has a negative impact or abridges voting in any way. But they can, each time they ask additional information, they can tack on a new 60 days. And once they get the supplemental information, they have 60 days from the receipt of that supplemental information to complete their review. If they don't complete their review within 60 days or don't interpose an objection, the assumption is you can go forward, that there has not been an objection to what has been proposed to the Department of Justice. So that is what you have in 1217. It's just a description of that process that I've just gone over. Determining, number one, from the Secretary of State's office, is it something that impacts voting that has to be reviewed by the Department of Justice? And then I've just given you some additional information based on federal voting rights law about what happens once it goes to the Department of Justice. 1218 says, okay, before it can be submitted to the voters, this charter, it does have to be submitted for legal review. And legal review does not happen at the Secretary of State's office. That's just a determination of whether there is an impact on voting or the governance structure of the school district. The legal review actually happens at TEA or by the commissioner. And what the commissioner is going to be looking at is, did we comply with Chapter 12 with respect to the development of this charter? And there is a timeline for the commissioner to review the charter that's submitted to the commissioner, and that's 30 days. And so kind of similar to the Department of Justice, no news is good news. So if we don't hear anything from the commissioner, or if we hear something positive from the commissioner within that 30-day timeline, then we just move forward with the process that's outlined in Chapter 12. If we hear something, then we would have to address it from the commissioner. 1219 talks about, after going through those two processes, assuming that we have to go through the DOJ process and going through legal review, about the process for getting this on a ballot for an election. And again, it is the charter itself that is being submitted to the voters. And the highlights from 1219 that I want to point out is that it has to be at an election for a charter to be effective, where we have 25% of the voters actually participating. So if we don't have 25% of the voters participating at that election, even if the majority of voters support the charter, it would not take effect, because we have to have 25% of the voters actually participating in the election. What is submitted to the voters is contained in subparagraph T of 1219, and I just want to read that to you because I think that helps to focus your work here. Whether the, and then you insert the name of the school district, shall be governed under the Home Rule Charter School District Charter, which is proposed by the Charter Commission appointed by the Board of Trustees, and under which only certain laws and rules apply to the district. And a provision of 12019 provides that we must make available to voters prior to the election 3 copies of the full charter in every location where it is required to be. And it's required to be at the central administrative offices of Dallas ISD and each campus of Dallas ISD. And in addition to making the full charter available, proposed charter available to voters, a summary of the provisions that are in that proposed charter has to be contained with that copy of the proposed charter that we make available. And again, 3 copies available at every location where we make that available. Now, I want to turn your attention to subparagraph B.
The 45.
Yes, yeah. Because there's been a lot of question about how soon can we call an election after this group has done its work, and after TEA has reviewed the proposed charter, and if DOJ has to review it after DOJ has to review it. In subparagraph B, it says that an election can be ordered, or an election can be held that occurs at least 45 days after the date on which the Board of Trustees orders the election. And so that's a little bit different, but it's not in conflict with what is contained in the election code. The election code says, for example, if there are several uniform election dates. There is the uniform election date where cities and counties and cities elect officers, and that's November of even years. There is the November of odd years, which is just the November uniform election day, and then there is the May uniform election day. For the November uniform election day in even years, so we're talking about this November, there is a different timeline for ordering an election than it is for the May uniform day or for the November uniform day in an odd year. I know that's confusing, but the legislator made it confusing. So for purposes of November of an even year, one has to call an election at least 78 days before that election. And so some people at first blush might read these two provisions to be in conflict, because the election code says 78 days you can call an election before you actually have an election. This says 45. I, in reading this, don't see that there is a conflict, because subsection B says that it has to be at least 45. So it could be more. So you could read those two sections together in harmony. So what I don't think you can do as a matter of law is read subsection B to limit or shorten the 78-day time period that's contained in the election day to 45, because it says at least. It doesn't say 45 days. 1220 talks about the charter amendment process. And so that's kind of after this commission has done its work. And let's say the charter is passed by the requisite number of voters at an election where the requisite number of voters participate, and the citizens or the board or whatever the governing structure of the district at that time decide or propose to make an amendment to the charter. What is the process for doing that? That process really mirrors very closely the process for just the development of the original charter. Either the board or the governing structure, by the requisite number of members, can put that issue to voters, or a petition issued to the governing body of the school district saying that they want an amendment to the charter, as long as it is signed by the requisite number of registered voters, can cause that to be placed on the ballot. And you have the same requirements for an election, except in having to have 25% of registered voters participate in that election. We drop it by 5%, 20%. The reason why I want to just highlight this, because this kind of goes temporally beyond what the work of this body would be, is it's interesting to me that the legislature has said several things about charter amendments. Number one, charter amendments have to be a single subject. So you could have more than one on a ballot, but each one has to be a single subject so that a voter can vote for them individually. And the other thing that I find interesting, that it's just something for this body to keep in mind, is in subparagraph I, that the governing body, whatever that governing body may be, after this work is done, cannot propose a charter amendment less than a year after the original charter was presented to the voters. So I just highlight that so that you have that in mind, and that's on page 8 of 13 in subsection I of section 2020. 1221 talks about the adoption process. And it's it is very similar to those of you who participate in elections to the canvassing of an election. So when we get the results of sending this proposal to the voters, having them vote on it, certify, canvass it, and present it to the board has to formally accept the will of the voters, and has to notify the Secretary of State and TEA of the results of the election. The charter that this commission develops has to have an effective date, and so when the board accepts the will of the voters, it is accepting for that charter to be effective on the date that's placed in the commission. So that's something to keep in mind as this body does its work, is to give your work an effective date, because that is also what is placed to the voters. 1222, we've already talked about the minimum voter turnout that is required. 1223, which is on page 10 of 13, we've already sort of talked about as well, which is certifying to the Secretary of State the results of the election. 1225 talks about a home rule school district may adopt and operate under any governance structure. The district may create offices, determine the time and method for selecting officers, and prescribe the qualifications and duties of officers. The term of any officer of the district is determined under 11.509. And if you remember when David was talking to you about the actual education code, Chapter 11 talked about the board or the governing structure of a school district, and Chapter 11 contains what are the typical lengths of terms of board officers that can be selected from. 1226 is a common provision that is contained in any statute where there can be a potential change to the governing structure of a school district, and that is or of any governing body. What happens in the interim? Do the officers who are currently in place continue their term, or do we elect new officers, and have staggered terms? What happens during the interim before we actually put the charter or the provisions of the charter in effect? And so essentially what 1226 says is whatever was in place at the time of the charter, those individuals complete their terms until we have an opportunity to stagger in whatever it is, the provisions of the Charter Commission. 1227, interestingly enough. Now remember, one of the provisions that the charter has to have in it is any reason for revocation other than what is in Chapter 12, or placing the charter on probation. And so what's interesting is there are really only 3 provisions that are contained in Chapter 12 regarding revocation or being placed on probation, and they're in 12.027. And that is if the school district has committed a material violation of the charter, they failed to satisfy generally accepted accounting standards or fiscal management, or failed to comply with this subchapter, so this is subchapter B of the Home Rule Charter School District, or other applicable federal or state law. And so any other reason for placing the Home Rule School Charter District on either reason for revocation or placing it on probation that this commission thinks is appropriate would have to be specifically specified in the charter, other than these 3 reasons. That's one of the content areas that I read to you earlier. 1228 basically lets you know that actually TEA and the commissioner have to have a process if revocation or probation ever became an issue, to give the school district an opportunity for a hearing, and the parents and the community of the school district an opportunity for a hearing and to be heard. So that's what 1228 is about. It is just a requirement that TEA and the commissioner develop a process for doing that. And you may have seen sort of and akin to that under Chapter 13 of school districts across the state of Texas when they have a board of managers, and sometimes when they're not successful with that board of managers, the commissioner comes in and either closes that school district, annexes that school district, or consolidates that school district. Process kind of similar that those school districts get to be heard in front of the commissioner or state agency for administrative affairs regarding whatever is being proposed, either it's revocation or probation. I just provide that to provide some context or some analogy. 1230 is the process for rescission of the charter. So we want to think of rescission as different from probation or revocation. Probation or revocation is when the school district isn't living up to the commitments of the charter for whatever reason, a material violation of either Chapter 12 or of a charter commission specifically placed in the charter by this commission. Rescission is a decision either of the voters or the governing structure of the school district to rescind the charter. And so that process is very similar to the charter amendment process that we talked about, or the original process for setting up the charter commission. It has to be done on the requisite vote of the governing body of the school district, or on petition of the requisite number of residents or registered voters of the school district. So a lot of mirroring the process. The process for forming this commission and considering a charter is similar to the amendment process once the charter has been designed and voted on and approved by the voters, and very similar to the rescission process. So a lot of parallelism there. And interesting, if you look at subparagraph E in 12.030, because I'm an elections person, it's one of the things that I do, and especially practice at our law firm, and I just think it is very telling that the ballot language that would be on a ballot for rescission of the charter is whether the home rule school charter district, whether the home rule school district charter of, insert the name of the school district, shall be rescinded so that the school district becomes an independent school district. So that would be the ballot language. So it all kind of perfectly mirrors from beginning to end this process. And then going back to the section that I skipped, and I believe that was on beginning on page 3. And that was 12.013. And that goes through, as a commission, what you guys should be thinking about in terms of laws that would be applicable and not applicable to a school district that's operating under a home rule charter. And so 12.013 talks about that a home rule school charter, even though we may be opting out of certain other provisions of the education code, here are the provisions of the education code and the laws that still remain applicable to the home rule school district. So any provision of this title, meaning the education code, establishing a criminal offense, a provision of this title relating to limitations on liability. So immunity, we can't opt out of immunity for our educators and for our officers who are on the governing structure. Any prohibition, restriction, or requirement as applicable or imposed by this title, meaning the education code, or rule adopted under this title relating to, and we have several things there that continue to be applicable to a home rule school charter district. Not surprisingly, PEAMS reporting remains applicable to a home rule school charter district. Educator certification, we can't opt out of that. And certain provisions of Chapter 21, 21.407, 21.408, and 22.001. And I'll tell you what those are. 21.407 is the prohibition on a school district or a governmental officer from coercing a teacher or professional employee from joining a specific group. And then the right of a professional, particularly an educator or teacher, 21.408, to join a professional organization that represents teachers, principals, educators. Criminal history records, can't opt out of the requirements regarding having to do our due diligence related to criminal history records under Chapter 22. We talked about Chapter 25. Once you talk about the board, you talk about the state level, the board, and teachers. Chapter 25 is where we come to students. So certain things about student admissions, who can come to a home rule school charter district, are still going to be applicable. I'm not going to be able to opt out of it. And certain provisions regarding school attendance. Also, not intra, but inter-district and inter-county transfers, we're not going to be able to opt out of. High school graduation provisions, special education programs, bilingual education, pre-kindergarten programs, and safety provisions related to bus transportation. All of those provisions of Chapter 34 that are listed there pertain to how we transport students and the safety standards that are required for school buses. We're not going to be able to opt out, or the commission is not going to be able to opt out of that. Remember, one of the things I telegraphed was financial accountability and integrity. So there are certain things regarding the computation and distribution of state aid that still remain applicable even after or if a charter were to be adopted. Chapter 33, we talked about, it involved extracurricular activities. There's certain specific information in 33.081 that the commission would not be able to adopt out of. Chapter 38, relating to immunizations and screenings and other types of tests, like for dyslexia and things like that, will be something that will still be applicable to the home rule school district. And then public school accountability under Chapter 39. Those provisions, subchapter B, C, D, E, and J, cover both academic and financial. So again, we're still telegraphing that that's still an important issue for the legislature. And then bond, this is not a way to skirt or to not comply with any bond obligations that the school district has or may have in the future. So those requirements are still going to be, we're not going to be able to opt out of those. And the purchasing laws under Chapter 44, if you remember when David talked to you about the division of the Education Code, Chapter 44 was all about public purchasing. And so those laws would still be applicable to the school district, even if a charter were adopted. And so that is sort of a broad overview of how we got here, how we go forward, the election process, what the minimum required for the content of a charter, and in thinking about provisions, because what a charter is allowing some flexibility to opt out of certain provisions of the Education Code, but now knowing what provisions of the Education Code still remain applicable to the school district, even if a charter is proposed and or adopted. And I just want to make sure the chair sees that we have some questions.
Sure, absolutely. I'm going to go from my left to right, Ms. Heisen.
Okay. Under, on page 413, you kind of skipped over the elementary class size limits, and I want to be clear that we have to maintain the ratios pre-K through 3 is a 1 to 22.
Is that section G?
I'm sorry, yes, section G.
Ask you a question again.
Okay, my question is, looking at section G, this then would require us as part of whatever organizational structure that we have to maintain the 1 to 22 ratio for pre-K, K1, and 2 and 3, I think it is.
That is
and there is nothing that would limit us from middle or high school. I don't see them listed here at all. Okay. And then because traditionally we've always had to get waivers on that 1 to 22, would the commission have the authority, have the right to waive since we're independent? Am making sense? You know, every year we get waivers because we can never keep the 1 to 22 straight.
As part of the charter, are you asking,
yes,
could waivers be built into a new charter? Not this commission,
yes,
but the charter.
Yeah, the charter. Yes,
right.
So the charter.
And the answer is? And
the only thing I'm not for sure about is under 25.112, if that actually includes the waiver, because there are several provisions in 25, and the only thing I want to look up is if 25.112.
Yeah.
So one issue is being sure about the size, is your point, and the other is, can a proposed charter still have waiver of that? And you're looking that up.
Right.
So while they're looking it up, next, Mr. Ranger, was that?
Oh, yes. I share your interest in the rescission provision. And could you clarify under 12:17, I believe it's B, the language you read was the board shall submit the proposed change to the United States Department of Justice. No, excuse me, I'm in the wrong section.
Could you give us the page as well as the section?
The page is, it looks like it's 12 or 13. Page 12 or 13E, I believe. I was in the wrong section. 12030E at the bottom of page 12. Okay, the language is whether the home rule school district charter or name of the school district would be there shall be rescinded so that the school district becomes an independent school district. My question is, does that not clearly establish or certainly imply that if you adopt a home rule charter school district charter, you are in essence leaving the status as an ISD? Because this language is saying, in order to rescind it, you would be making a decision to convert back to an ISD. So it clearly suggests, strongly suggests, that is some kind of conversion going on here if you adopt a charter under this provision of the charter school law of the statutes of the state of Texas, that you are converting the status of the district away from an ISD, because rescission converts you back to an ISD. You can't convert back to something when you never left it.
It depends on what's in the charter, and it depends on what you mean by being an ISD. If you mean by being an ISD, having taxing authority in the ability.
What does this mean?
Mr. Just let her finish it. I'll give you a chance to respond. Ms. McBride.
what this provision means is you are returning to your original state, which means you are subject to all of the education laws. Becoming a charter, you're, depending on whatever the commission determines and what is approved by the voters, you are not operating like a traditional ISD because you're not subject to all of the laws of the education code.
So are we saying there are two kinds of ISDs? I don't know of that. So this language just implies, and I'll leave the point, this language clearly implies that if you adopt such a charter, you are changing the status, the legal status, from an ISD to something else. Because otherwise, if you rescind it, you could not rescind it and go back to something because you never left it. So it clearly implies that the legislature intended under this charter school law, it provided a revolutionary, radical way to charterize a whole district and to change the status. Just one more point on that. TASB, the Texas Association of School Boards, has a status for ISDs and it has a status for charter schools. TASB has clearly implied that the conversion to a charter school district charter would remove you as an ISD and change your status to the charter school status under their rules.
And, well, I know, I just think other charter schools don't tax.
Right, there's a specific provision in Chapter 11 for changing the name of the district. And I think the point Lisa and I would both make is whether you adopt a charter or not adopt a charter, a district would still be subject to most of the laws applicable to an independent school district, and it wouldn't change the name of the district unless that was actually part of the charter provision to change the name of, in other words, Chapter 11 says it creates a mechanism to change the name. So that could be something that a commission recommended to say we want to call it something else, but the name of the legal name of the district certainly could remain Dallas Independent School District.
Let me just see if there's any other questions around the table, and I'll get back to you, Mr. Ranger. Does anyone else? I want to be sure questions are heard.
Well, that was my point. Is it the terminology? I took it almost as a name change. I wasn't sure if that's what it meant, because I mean, you can basically have a charter and still call it Dallas Independent School District.
You could.
Okay.
Right.
That's what I thought.
Mr. Freeman, and I'm just going to go
or you
down
could
the
change
table.
it.
Or you can change it.
That's right.
And also, if you could just, I guess, clarify, there's a difference between a charter district and a charter school in terms of like the bond issues, taxation, all that stuff, right? Because it says that we would still have to be applicable to like a tax structure and creating all of that, whereas a charter school wouldn't. Is that correct? So we would still have some of the capabilities of an independent school district that aren't the same restrictions on just an individual charter.
And you're not changing your legal boundaries, your meets and bounds, anything like that. All of that remains the same. And in fact, in the proposition that is submitted to the voters, what is not being submitted to the voters is, you're still referring to the school district, as a school, if you look at the proposition that's submitted to the voters for adopting the charter.
Okay, just one at a time. Would you like to add
Sure.
to that?
I think there's a technical point here. It could still be Dallas ISD, or there could be a proposal to change the name. The only point I want to make is when we call school districts independent districts, what does that mean? Independent of what? It certainly doesn't mean independent of the state.
Right.
School districts are creatures of the state. They only have the powers vested by the state. The history of the word independent means independent of cities and counties. The Great Reform in the 1920s, primarily following World War I, was frankly a recognition that education was too important to simply be another department of city and county government. And so the word independent you know, it's kind of a rose by any other name is still a rose, really refers not to your relationship to the state. It refers to your relationship to other units of local government. That could be changed by the charter, but it doesn't have to be. And so, you know, I think you would have to look and see just what the specifics of a particular proposal would be.
I'm just going from my left to right. Ms. Gutierrez, did you have a question? Okay. Mr. Garza, pass. Mr. Blackburn?
I had a question on a different subject, so I'll wait.
Okay, if you'll hold it. Mr. Dees?
Yes, I had a question about the change of governance and whether or not, if under a home rule charter, if the commission proposed a change of governance that included a governing body of the district that was not an elected body, if that non-elected body still retained the taxing authority, taxation without representation.
All right, if we'll just hold the public
Sorry.
comments.
I'm sorry, where are you?
My question is really about section 12.001. I mean, I'm sorry, 011
Did you give us
on
a
page 2.
Thank you.
And about the taxes. And there were a couple of comments from Learning Council about the about changing, a proposal by the commission that would change the governance of the district. And if you proceeded to change the governance of the district, and let's say we decided we didn't want a school board anymore, we wanted something that was appointed. And you got 20, 30 people together and appointed them. Would they have the power to tax? And that's, to me,
Pretty fundamental.
Is a pretty fundamental question. I mean, it doesn't seem to really address that. Although it does say, if you put it in the charter and the voters pass it, so the voters can waive their right to be represented in taxing matters to an appointed board.
And the response to that is twofold. To answer your question directly, you're absolutely right. It does seem like Chapter 12 gives this commission the authority to change the governance structure of the school district, and there aren't any sort of limits to that authority, it would seem, at least under the express language that we have in Chapter 12. And so that would be one of the things that the commissioner, when we have that 30-day legal review, would need to look at, and possibly the Department of Justice, because it might be a voting structure that requires pre-clearance for the Department of Justice.
Because
to answer a question,
just let her finish,
yes, to answer a question that you didn't specifically ask, but I think I need to go ahead and put it out there so that commission members can start thinking about this. Remember that Chapter 12 allows the commission to opt out of certain provisions of the education code. Remember, Dallas ISD, all of the provisions regarding Dallas ISD and its governance structure is not necessarily contained in the education code.
Well, I'll give you a follow-up question. I just saw your face.
I'd like to hear what everybody. Would you say that again?
Sure.
Because
essentially what Chapter 12 allows this commission to do is to look at provisions of the education code and say yay or nay, except for those provisions that specifically still remain applicable to a home rule schools charter district. What it doesn't seem to allow this commission to do is to say yay or nay to laws that are outside the education code. Certain school districts, including Dallas ISD, have their governance structure actually described in a code that's outside the education code, in a special bracket bill that applies to the school district by basis of its average daily attendance or student population. I think there are only, is it 2 or is it 3 school districts that have those special bracket bills?
There, The ones I'm most familiar with are Houston and Dallas. There used to be a bracket bill for Fort Worth that was in the education code. Austin in the 1990 census actually grew into the Fort Worth bracket and became subject to that. In the 95 recodification, that provision was repealed, but the continued application to Fort Worth and Austin was grandfathered. So the two that I'm most familiar with, and we represent Houston ISD, I'm most familiar with the Houston and the Dallas.
Okay, just a short follow-up comment there is I'd like to at some point hear a little more about how that would restrict this commission. But finally, I would just like to ask you one other question, which is, I don't read anything in chapter 12 or anything in the information that we approved from the school board that requires us to do anything at all.
That's correct.
And that there's been, there was a lot of, we're sort of getting this momentum going, talking about what we might do. And at some point, I would hope that a very near future meeting, we could just have a very frank discussion about whether we want to do anything at all first.
If you look at the one of the charges or proposed items in the operating, the second piece, what was that question? But I'm going to ask you to hold it off so we can get around the horseshoe. Mr. Flores, if you have a question.
Well, I was going to ask, point something out and then ask something. Maybe I should ask it in the form of a question.
That would be helpful.
So I mean, I'm looking at structurally. Mr. Thompson described kind of the entire structure of the education code, which is only a piece of what applies to ISD and whatnot. And then we look very specifically at this one little specific piece. But just looking at it structurally, it is very, very clear, at least on the structure, that a home rule school district charter, not particularly artful, but it is what it is a whole different section from what's an open enrollment charter school.
Correct.
Absolutely. With the changes that
Correct.
with the huge differences, right?
Correct.
Even in a home rule charter, home rule school district charter can tax, we can issue bonds.
Correct.
You want to just speak up?
So the question is, so the question of these two, by the statute, are completely different. Yes.
They are similar, but they are very different in some very significant regards.
And then the other question I had more kind of, so that had to do with the specific structural issues. But looking at the section 12 and this opportunity to do something, not do something on this home rule school district charter, is not any different than what the city of Dallas is going through right now. They're going through a charter revision, and is it true or not that the fellow that wrote this was thinking about cities when he wrote this chapter of the home rule district charter? And he said so at least in the when he was interviewed about it.
Former Lieutenant Governor Ratliff probably was analogizing to cities. I know him well. That's probably what was in his mind. I'm never going to presume what the 181 members who actually voted were each individually thinking. So I don't. We're left with what we have to work with here, but that probably is, to some degree, probably where he got his thought at that point.
Okay, we're going to.
I just wanted to clarify to make sure I understood clearly, and back to Mr. Ranger's point, actually, with charters, what we typically think of as charters, and an ISD, and maybe I think what I've now seen sometimes as an HRD, being that in an open enrollment charter, because you could be a charter district, not an HRD, but you have several schools. but you don't have taxing authority and you function strictly off of your ADA, and your enrollment is determined within the charter you write, right? So I could write one and I'm going to be, let's say, I'm going to serve Bexar County in the San Antonio area, and so I'm going to allow all those kids to come. The difference then, why TASB calls those charters separate from ISDs, is that taxing, primarily the taxing authority issue, functioning only on ADA, which also allows them to opt out of other parts, like teacher salary requirements and so on. In an HRD, the defining boundaries are already given. That's some of the difference. Therefore, the taxing authority still remains with it, whether it's an ISD, called as an ISD, or an HRD. So the ISD, HRD can be one, or are in fact one and the same, and remain so unless a commission in a charter selected a different name. Is that right?
Let me just see, and I think there's multiple questions about the authority the charter could have, that a commission could write. And we're asking questions around the taxing, bond, and financial capability as a new district charter, as opposed to an individual school charter that could be within an ISD. So,
Could they clarify that?
yeah, I'm going to ask him to, I'm just trying to summarize. That give me a chance.
So the question
Well,
is...
I'm just what I think we're hearing.
Well, one other thing, if I may.
Yes.
Is it not clear that Chapter 11 is the ISD? The general provision for Chapter 11 school districts. Chapter 12 clearly states this is about charters. Charters means exactly what it says. It means, in the essence, of different forms of charter schools. So, are we not saying, just for clarification, that not that this commission will, but if it did, choose such a radical experiment on the kids of Dallas ISD to try to perhaps create a myth that this would be the solution to our educational problems, and it would not. But if we did, the point is, are we not then operating under one charter for 225 schools? In other words, the charter would be, if it were approved by the voters, at a time when enough turnout could be there, and that's a political, you have to decide which time you want the vote to occur in order to get the 25% or whatever. But the point is, if it did happen, then every school in Dallas ISD would it not be operating under charter, because that would be the governance, that would be what the legislator has provided. Is that correct?
It would depend on what you recommend and what the voters approve. Chapter 11 covers a whole lot of different subjects.
No, I'm talking Chapter 12.
I know. What I'm saying is you may very well still be subject to most of Chapter 11, is what I'm saying. In other words, you may not decide to opt out of everything in Chapter 11.
Would we be committing to the Commission of Education a charter for approval?
It is a charter that modifies the operation under specific statutes.
But it would be a charter.
It is a charter that modifies, yes. But again, the name of the district is less part of the... Dallas used to be not Dallas ISD, it was the Dallas City Schools.
Yes, but it is a charter. Okay.
Yeah,
but I mean, the name could still be a Dallas ISD.
No, but I mean, the authorization is a
Okay,
charter.
I'm thinking...
Or statutes.
Do we want a second round of question? I mean, we're not going to all learn this all tonight. We're just getting it on the table. All good questions.
Obviously, we will have a chance for additional questions at the
yes,
next meeting.
Yeah.
Okay.
What I'm saying is, first round of questions, you need study time. It's not a pop quiz tonight. I don't know if we've had our DOLs or whatever, but we're trying to get your questions on. Mr. Garza, one last question.
One last question in light of some of the discussion I've heard here, and I want to go back to page 7 of 13, section 12.018, legal review, and it really has to go with the commissioner shall review the proposed charter to ensure that the proposed charter complies with all applicable laws and shall recommend to the commission any modification necessary. One could read that we come up with XYZ, the commissioner says it needs to be ABC, and that's what's going to go to the voters. Could the commissioner in fact do that? And the reason I say that is because most recently we had the city put together a charter review commission, and when it went back to the city council, they chose ABC rather than XYZ. So a lot of their work was for naught. So I asked that in that light. Could not, in fact, the commissioner come up with ABC as opposed to XYZ that we are doing?
If the commission were to recommend something ABC and the commissioner comes back and says you can't do ABC, I recommend you make the following changes XYZ, it doesn't automatically change the recommendation and go to the voters. The commission might very well decide we don't want to do XYZ.
Oh, so it would come back to the commission?
It is a recommendation.
Okay.
In other words, the commissioner doesn't dictate, and you're still, you know, moving forward. I think the commission then gets to look at your proposal again and say, do we want to go forward with that proposal?
What I would suggest, yes, well, okay.
Just real quickly, just a scenario where the school board didn't exist, how likely would it be that the Department of Justice would even consider it? I mean, consider approving anything like that, where every child didn't have some form of representation? How likely would it be that the Justice Department would approve any recommendation coming from our commission that excluded children within our district, or our charter, or whatever you want, home rule charter?
That excluded children?
Excluded.
Them having elected representation.
You mean from having elected, we're talking about the representative, not talking about attendance boundaries.
Right, I'm just talking about to where parents would feel like every student had a voice.
So are you saying it completely excluded elected representatives, or
Well,
went to
I'm
at
saying
large from single member districts?
I'm saying kids from South Dallas, West Dallas, East Dallas, North Dallas, where they had someone who actually spoke for them or spoke for their parents.
Section 2.
Right. It's interesting that you asked that question, because this was written in 1995.
Right.
In terms of the Department of Justice preclearance. What isn't clear is whether the state has voluntarily said that all of these things, if they have an impact on the governance structure or impact voting, go to the Department of Justice for preclearance under just voluntarily.
Right.
We just want, or whether what the state was saying is, we, the state of Texas, are under the formula for coverage under Section 5, under the Section 4 formula for Section 5 preclearance. And so we're just telling you have to preclear because as a political subdivision in the state of Texas, you're within the coverage formula. If the latter is actually the reason why the legislature put that language in, many of you kind of know about the decision in the Shelby County U.S. Supreme Court decision that struck down the Section 4 coverage formula. So it's possible that DOJ reads this and says, you know what, you're only coming to me because of the Section 4 coverage formula for Section 5 preclearance, and we have no authority here. Or DOJ might say, oh, you're coming to me because the state has voluntarily submitted to the jurisdiction of the Department of Justice and actually do a review. It's just not clear because this was written in 1995 and Shelby County came out last year.
Can I add one comment?
Yeah.
There are 3 provisions to keep in mind under the Voting Rights Act. Section 2, Section 4 or 4A, and Section 5. Section 5 is preclearance. Think of this room as preclearance. Section 4 or 4A is the door into the room. It's the coverage formula, who is subject to preclearance. The Shelby County decision said your door is based on data that is so outdated that it's functionally arbitrary. They did not touch Section 5 directly in the opinion. So there's some ambiguity as a consequence around that. It is very clear they did not touch Section 2, which prohibits any action in relation to voting that has the effect of discriminating on the basis of race, ethnicity, and the covered requirements. And so whatever Shelby County did or didn't do with regard to pre-clearance, it definitely did not touch Section 2. So I think that's always something for this commission to keep in mind.
But that would be a Section 2
It's
issue, would be a lawsuit
That's
as
not
opposed.
a Justice
That's not a
Department
department,
issue.
yeah.
Right.
Okay. Lot of homework to do, a lot of things to do. I'm going to come back to Mr. Blackburn, who had another question.
Quick question. On pages 6 and 7, the legal review as well as compliance with the Voting Rights Act, are those occurring concurrently or one after the other?
The Voting Rights Act is after you hear back from the Secretary of State. So you could submit simultaneously to the Secretary of State and the Commissioner. And the, I think the voting rights is triggered by.
You don't get to the Department of Justice unless it's triggered by a decision at the Secretary of State. So the Secretary of State is the one that does the review and says whether or not we have to go to the Department of Justice. But so you could be going to TEA and the Secretary of State at the same time, but you couldn't be, you could not be going to the Secretary of State and DOJ at the same time. That makes sense.
Those would be sequential.
Okay.
All right. Okay.
Very quick.
Okay.
Because it triggered a thought. So,
okay.
So what if the commissioner says, oh, there's no voting rights issue here, doesn't have to go to DOJ? Then that commissioner is deciding whether or not it goes.
The Secretary of State.
Secretary of State. So Secretary of State is the one.
Right.
Okay. Clearly a lot to think about, and I appreciate all the questions. I'm looking at the clock. We've been at this for 3 hours. And going back to the first, let me thank our counsel here down to my left. I appreciate it, and giving us a lot of food for thought. Obviously, we're going to collect more questions about how this actually operates and what the language means as we move forward to some resolution about a consensus understanding about what the law allows us to do or not to do. So the items that on your agenda that we moved, and I'm looking at there, one was the election that we agreed to move towards the end of the agenda. And what I would propose to you is that there was a handout about some rules for operating procedures. I would suggest that we roll that to the next meeting, give everyone a chance to look at it. I think the board just kind of put it out there. There's nothing sacred about it. I would ask for you to look at it, edit it, make suggestions. We can put it on the agenda. But I would like, if you would like to, and I think it's important, and simply to have someone to chair a meeting if I'm not available, to have an election. And even though I'm currently chair, Mr. Harris did such a good job, I'm going to ask you to come forward in my behalf so I can get some water here. Just conduct, if this is okay, as a point in the agenda, to have an election of the first vice chair, second vice chair, and secretary. Are there any objections at this hour? Mr. Blackburn?
Unfortunately, I still don't know the other 14 commission members anymore. I did 3 hours ago.
All right. I appreciate that observation. We can suspend that. I think at least the vice chair, and I'll tell you just as a point of chair privilege, if the meeting is in the next 2 weeks, I will be unavailable to chair it. So I have a personal urgency. If I might just take one more note of personal privilege here. I'm retiring this week, and I've had a long trip to see my family out of town. So for the next 2 weeks. So just put that in front of you, just as a matter of personal privilege. If we can get to a vice chair, and maybe hold the other two off, though I'm willing to consider, if that's the will of the group, the other two officers, just simply that we can keep things moving in case something happens to me.
I nominate Stephanie Lisande for vice chair.
Hold off 1 second. All right, I'm going to just ask Mr. Harris to do that since he conducts meetings. So, Mr. Harris, would you just... Yes. Is there a point there? Does anyone object to his just running that? I don't mind doing it. I'm just going to defer to him.
I misunderstood, I guess.
Yes, sir.
I thought we earlier said we were going to delay the other officers until we had another meeting. Did I mishear that?
Yeah, I thought it was to put it at the end of the meeting. That is, we agreed on the 3 additional officers and try to vote at the end of this meeting.
End of this meeting? I
Yeah.
see.
Knowing we have incomplete information, and I certainly recognize that from Mr. Blackburn. So I'm going to ask and defer to Mr. Harris just to conduct those 3 elections. We did agree to 3 additional officers to help move the work forward here.
Okay, so the first election is going to be for the first vice chair. Nominations, Dr. Flores.
So I would nominate Stephanie Elizalde.
Stephanie Elizalde. Any other nominations for first vice chair? Ms. Newsom?
Yes, I'd like to nominate teacher Ron Oliver.
Ron Oliver. Ron Oliver for first vice chair. Any other nominations? Okay. So we have 2. So we are now going to vote for the first nominee by show of hands. All in favor of Stephanie Elizalde? You can vote for yourself if you like.
Stephanie, you can vote for yourself.
4,
Como dice su mamá.
Vote for yourself. 6. Count at 6. Okay. And now for Ron Oliver. Show of hands.
The chair's allowed to vote, Mr. Harris.
1, 2, 3, 4, 5, 6.
Ron's vote for himself to break the tie.
Come on, Ron.
Come on, Ron.
We have 7. So, Mr. Oliver would be the first vice chair. Congratulations.
Thank you.
Here, just pass this down to him, right?
Okay, now we have nominations open for second vice chair. Dr. Flores is quick on the hands.
So I nominate Jerome Garza to be the second vice chair.
Okay, we have Jerome Garza, second vice chair. Any other nominations?
I move for acclamation for Jerome Garza.
Okay, Mr. Garza, you are now second vice chair. Our last office is the office of secretary. Nominations for the office of secretary.
You have one down here with his hand up.
I nominate Shirley Eisen Newsom for secretary.
Okay, Ms. Newsom. Any other nominations?
I vote for acclamation for
Yeah.
Thank you.
Here you go. Ms. Newsom, you are now the secretary.
Thank you.
And thank you, Mr. Harris, for
Chair, that
doing
concludes
that
our nominations.
on our behalf. I think I mentioned I would welcome suggestions on, well, before we do that, let me see, housekeeping. Yes, would you walk us through what's in the envelope? Everyone, I mean, not all of us, you can open your envelope now. It's kind of like Karnak the Magnificent. You can get your-
What you have, or what you should have in the envelope are some instructions, but most importantly, you have your Dallas ISD username and password. That's what you will need to access the system. What I believe what's not in there is the way you access that, which is you would go to, well, if you're a Dallas ISD employee, it's a non-issue. So for the others, you would go to outlook.com/Dallas ISD.
Repeat that again.
Yeah.
Outlook.com/Dallas ISD.org. Outlook.com/Dallas ISD.org, and then you enter your username and then that password.
I just found my pen. Did you say that? Outlook what?
Outlook.com
Okay.
/DallasISD.org.
Thank you.
And if you have any problems with that, just
Call me.
call 1-800. Give me a call.
Mr. Beasley.
I need to see some of that.
Okay, so let me just say that we will have 2 homework assignments. One is Chapter 12 and the code in general. As much as you'd like to delve into it, we'll put that back on the agenda. And the general operating procedures, I would like to have you look at that were distributed and posted. Make comments and edit. If you will get it back to me as soon as possible. And then the third item I would like is if you have any meeting date and time conflicts that you absolutely can't make, if you'll let the chair know, I'll try to group all that together so that we have some consensus about when we can meet. I know you have time issues and other people have mentioned that. So please just send that to my DISD email account, which I promise you I will set up tonight. Yes, I submit.
Yeah, I was going to ask about that. Is it possible, Mr. Chair, if you could send out a group of all of ours so we can begin communicating if we need to with each other on this account? Because I personally do not wish to use my personal account for this work.
I think if you can do this within a day, this will be our official means of communicating.
Okay, and you'll get us everybody else,
Yes.
because we don't have each other.
Right. Yeah, so everyone has the
thank you.
name, their email address, and again, if you just do those 3 homework assignments for me. Look at the rules, look at the, give me some, whatever meeting dates absolutely are, and times are conflicted out, and start thinking about Chapter 12 and what it means or doesn't mean, and compile questions, and we'll try to get them answered. Is there anything else for the good of the order, Mr. Freeman?
Just really quickly on the email address thing, for those of us who already have a Dallas ISD email account, do you want us to use the second one for this, or is it acceptable to just use
your current.
Okay, then can we give you our current one instead of this one, so that we don't get emails sent to this?
I can get yours already.
Okay.
Actually, I think I already have yours on my main, on my master list.
It's already, you already have it, right? Right.
Right, because if you receive my email, then.
Correct.
Any other questions, Ms.
I'd just like to thank members of this group. It's been a pleasure working with all of you this evening. And I think that moving forward, my sense of comfort of doing something on behalf of the children, and not the adults, has heightened, because I think this group is going to be working to focus on the children. And I thank all of you for the opportunity to work and serve the children.
And I would second that. I'd entertain a motion to adjourn.
Chairman Weiss, a public question.
I'm going to.
What opportunity will the public have during this process?
We're going to make it clear on the website when we'll take public comment. You can assure that as I'm chair, we'll have all the public input we can. I'll take a motion to adjourn.
So moved. Second.
Okay, all those in favor say aye.
Aye.
Meeting's officially adjourned at 8:40. Thank you.